the concerned investigator to complete the investigation
In accordance
Impartial.
in accordance with law and impartial.
in accordance with the private respondent is interested in the
Lordship.
subject to the cost complaint.
This is a counter blast. Already we have already lodged a FIR against the husband.
Submits that the complaint lodged by the is a counterblast to the earlier complaint lodged by the private respondents with the police authorities. Further surveys that the person with the complaint lodged by the private respondent and FIR has already registered.
Yes.
Investigation.
It's good.
Grateful.
Next,
Item number 4.
this more what happened?
For Lordship, this is all. For Lordship, one. If W, which petition? First one was by the husband, and second is by the father-in-law.
This is by the no, this is by the husband.
This is by the husband.
By the husband.
Kindly consider page.
The father-in-law of the private the demands of the patient is the husband of the private respondent number 4 is that the police authorities have got, yes, what is your instruction?
Same as previous one.
Is that no steps have been taken by the police authorities in spite of the fact that a complaint has been lodged by the submission is same.
Same Lordship.
Same.
My lord, if kindly considers page 15 of my writ application.
Yes.
15, annexure P3.
Yes.
And Lord, kindly consider these photographs. What our information is, all the a section of heart or
Remedy from the concerned jurisdiction is approached.
Good.
Item number 5.
item number 5 is also I am for the petition.
I update you after for the respondent number 5 to 8.
Is the
Yes.
This is also a matrimonial dispute between the petitioner is the wife.
Yes, what is this?
Well, instruction yet not come. This is the matrimonial dispute. The High Court has been used for file a 156(3). And it has been used as a 156 before as a CGL.
My lord, this is better.
The patrimonial dispute, they have made a complaint. I mean, that he has not been considered their allegation.
My lord, may I, my lord?
Please inform them that the complaint has not come.
No, my lord, the complaint has been registered as an FIR, my lord. As of right now, the complaint has been registered as an FIR. Now, my lord, there is a lineage to this case, my lord. If I may apprise your lordship in very nutshell, my lord. At best, my lord, in a nutshell, my lord, I can say this is a case for use of jurisdiction under Article 226 for pressurizing the investigating agency to register a case and unlawfully arrest the brother of the husband respondent. My lord, I have prepared a short list of dates. If your lordship would kindly see it. My lord, not only FIR has been registered. Today, the hearing of this petition, yesterday, my younger brother has been arrested in a new case. Previously, also, 498A was registered against me in 2025. In that matter also, my lord, on the date of registration of the FIR, I was arrested. Here, today, my lord, yesterday, my younger brother has been arrested in a case of attempt to rape against the wife. Now, my lord, kindly see the list of date. My lord, your lordship may see what has happened here in this matter. Sir, my lord, kindly sees. In 2016, my lord, the marriage was solemnized. In 2017, birth of the minor daughter, my lord. My lord, the whole case, the lineage of whole case is based on the custody of the minor daughter, my lord. My lord, in 25/6/2025, the first case was registered under section 85 and 109, that is 498A and 307, my lord. My lord, in that case, on the very date of the registration of the FIR on 25/6/2025, I was arrested. The respondent number 5 herein was arrested on the very same date. My lord, very importantly, my lord, kindly takes note that, my lord, on that day, CD did not come. 7 days I was in custody. The first day CD comes before the learned ACGM Shiliguri. I was granted bail, considering that the simple injury was simple and there was no intention. Subsequently, my lord, they lodged a complaint before the Fashida police station on June of this year, my lord. 23rd June of 2025, alleging an incident of December 2025. Sorry, June of 2026, alleging an incident of December 2025. 7 months delayed complaint, my lord. Police does not take any step. My lord, this writ petition was filed on 9th of this month. 17th of this month, my lord, police initiates an FIR. My lord, how this is permissible, my lord, I don't know. Lalita Kumari specifically directs 14 days, my lord. However, if after elapsing of that, on 17/7, my lord, case gets registered. Till right now, that FIR is not uploaded in Darjeeling police website. My lord, yesterday, my younger brother has been arrested, my lord. This is the stage, my lord. The whole thing, this filing of this petition is just to take custody of the minor daughter, my lord. That is my instruction, my lord. One advocate, namely Suraj Bhattacharya, day before yesterday, met with my instructing advocate, said that if you just give me the custody of the minor daughter, I will withdraw this case. The minor daughter, due to the behavior and lifestyle of the mother, petitioner mother, did not want to go. The minor daughter is here present before your lordship, can be asked to also, did not want to go. For that reason, my lord, yesterday my younger brother has been arrested for an allegation of attempt to rape of December 4th, 2025. 7 days she was in, 7 months she was in hibernation. Suddenly she comes up with a complaint, my lord, files a writ petition, my lord. This is the stage. Yesterday I was arrested. First time also, my lord, attempt to murder given, no opportunity for anticipatory bail. I was arrested on the same date. Here also, my lord. 17th, my lord, the case gets registered. Till today, Darjeeling police has not uploaded that in their website. I was arrested yesterday, my lord. My lord, yesterday also, before the learned FTGM Shiliguri, he did not come. Right now I am in custody, my lord. This is how Article 226 jurisdiction is being used by this petitioner. This is absolutely a malafide institution, my lord. I have Sakedi Basu, my lord, paragraph 25, which specifically says that writ petition cannot be used for pressurizing investigating agencies like this, my lord. My lord, kindly takes note of the list of date, my lord. Your lordship will be clear about it, my lord.
What if I have been registered, instructor have come?
If I registered and respondent number 6 arrested, my lord.
Grievance is not under change. এটা হাতে দিও না, এটা তোমার instruction.
এই সুরজ ভট্টাচার্য
Open it to the
ওরা প্রেজেন্ট আছে
My lord, as per the allegation against Mr. Suraj Bhattacharya is concerned, he is the filing advocate presently. He has confirmed that he has not made any calls.
তুই কি কথা বলিস?
Apart from that,
ঠিক আছে বলতে দে।
kindly consider my writ petition. It has been, the private respondents are very influential. Kindly consider first, my lord, various complaints was lodged. Kindly consider my writ petition.
The complaint of 23rd of June 2026, what is the incident it has annexed there?
23rd of June.
My lord, that was in 2025. It is my specific case.
Where is the explanation for the delay? Where is the explanation for the delay?
Yes, my lord, it is.
Lodged in the complaint.
It is
Not in the writ petition. Please show me the reasons for the delay in approach of an incident in December, complaint lodged in June.
My lord, that was the only problem, that complaint was registered. My lord, in spite of sending that complaint before the police authority, under the influence of the private respondents, police authority was over and over again calling my client to come over.
The validation incident of December 2020.
Yes, my lord.
Hardly not of- The complaint is not in Calcutta. Where is the explanation for this delay of more than 6 months?
My lord, whenever I am,
In the complaint, please show me.
My
What
lord.
prompted you to approach the police station after 6 months?
my lord, kindly consider paragraph 12 of my brief application.
Not the application, the complaint itself.
My lord,
Because the deed application was not considered. It's the complaint.
my lord, this
Where is the
complaint,
explanation for that delay?
there is no specific explanation for the delay, but kindly consider the next paragraph. Kindly,
How could it be registered as an FIR then?
my lord, this is the first time from the respondents, I am being informed that the FIR has been registered. But till
Now
then,
what do you want to do? Now what do you want to do?
if police continues with the investigation and takes up the matter, I don't have any problem, my lord. It is not about the custody of the child. Kindly consider, I have been repeatedly.
Lord, may I
being
indicate only one thing,
assaulted.
my lord? My
Apart
lord,
from
kindly
that-
sees 23/6/2026 complaint was given to the police station. My lord, when the complaint gets registered, 17/7/2026. Kindly sees, my lord, the formal FIR is not there in the record. It should be with the instruction with the state. 17/7/2026, the complaint gets registered as an FIR. On which basis, my lord? Lalita Kumari specifically gives 14 days, my lord. My lord, if 23/6 complaint is, written complaint is made to the PS, how can 17/7 it can be registered, my lord? Now, my lord, I will, my lord, kindly considers my prayer, my lord. Yes, not my application, my lord. I will file a petition by tomorrow, my lord. My lord, kindly considers one thing. As of right now, my lord, let no coercive action be taken against other respondents, my lord.
My lord, kindly.
My lord, I am in jail, my lord. I am in jail yesterday for an allegation for 9 months.
Must be done in a petition filed against this.
When it is before your lordship, kindly considers, my lord. My lord, then keeps it tomorrow, my lord. I will come up with an affidavit, my lord. Keeps it tomorrow.
Takes place.
My lord. My lord, I'll file a separate petition, my lord.
Submission on the article. These are the instruments of the five of the private respondent number 5. Five of the private respondent number 5. Alleging that in spite of a sincere complaint lodged by the petitioner, no steps have been taken. These authorities registered on the complaint discloses copies of the law. For the number 5.
5 to 8, my lord.
Subjects that the petitioner has filed this petition. The wife of the respondent number 5 has filed this petition in order to create pressure upon the in-laws of the petitioner to give custody of the minor son or daughter.
Daughter, my lord.
Minor daughter to the petitioner. The planner actually for the petitioner submits that the marriage between the petitioner and the age 30, 2016
None.
the minor daughter was born in the month of March 2017. The petitioner lodged a complaint on 25th of October 2025 against the respondent.
Yes, my lord. No, my lord. All the respondents, my lord. All the.
because the private respondent was the private respondent. On the basis of such complaint, considering all these teacher case number 286 of 2025. There is 23 of 85 and 179 of DNS has been registered. Subjects that the fifth respondent was subsequently enlarged or bent by an order passed by
Planet ACGM Siliguri.
Submits the charge sheet in the opposite case as already been filed under section 85 and 109 of yes. Subjects that that thereafter the teacher then lodged another complaint by later dated 23rd of June 2026, alleging that the brother of the fifth respondent, that is the sixth respondent here, attempted to commit rape upon the petitioner here on 4th of December 2025. Submits that there was a long delay in lodging of complaint with the police authorities. There was a delay of more than 6 months.
7 months.
A delay of more than 7 months in lodging a complaint with the police authorities in respect of an incident that occurred that allegedly took place in the early part of December 2025. So further subjects that a subsequent complaint was also lodged with the police station by dated 29th of June 2026, alleging the same incident of
Attempted.
the same incident which alleged to take place on 4th of December 2025. Further subjects that in the meantime the FIR has already been registered on 17th of July 2026. Since the FIR has already been registered, therefore is the considered view, this police court declined to accept the contention of the petitioner that there was inaction on the part of the police authorities in taking steps pursuant to the complaint, pursuant to a related complaint lodged by the petitioner. WPA number successor accordingly stands. Postcard will be open to the respective parties, take steps in accordance with law.
Another thing, paragraph number 12, Miller. They intentionally suppress the fact that the 2025, the FIR has been done. That has not been mentioned.
A lot of matters are suppressed in the deep petition, my lord. This is just one of them. I'll come up with a deep petition, my lord.
Those are the appeals of the
Junior government data.
Senior government.
Dear government. Okay.
Yes, sir.
Suppose that second option that the FIR has already been registered, so it submits that several facts have been suppressed in this. In reply to that, denies the allegation of the petitioner that denies the allegation of the petitioner that the I think this is what I wanted to get custody.
My lord, one line may be added for Phashidawa police station for acting in this manner, my lord. Otherwise, my lord, today other respondents will be arrested, my lord.
Yes.
My lord, I can only ask.
Number six.
I'm so grateful.
Six lordship, I'm appealing for the decision of madam.
I'm for the state, my lord.
Madam, my lord, where lordship finally comes to page 19 first. The petitioner, the father of the petitioner instituted a title suit for declaration under partition of his land from the unpartitioned land in plot number 220, plot number 220. And his land is 5 decibel. Now, my lord, the petitioner's father's land.
Yes.
5 decibel from the unpartitioned land in plot number 220. Now thereafter lordship finally comes to page 23. My lord, grievance is my lord my declared land, where the private respondent has made the unauthorized construction. I made the complaint to the Jalpaiguri Municipal Corporation. My lord, there's a provisions under section 66 to 87 of the West Bengal Municipal Corporation Act to conduct an inquiry, giving the opportunity of hearing to all the parties and to sort out the issues. My lord, there is no step from the municipal corporation lordship. My declared land, where my
Where is that decree of declared site?
lordship kindly comes to page 23 first. This is the preliminary decree. The share of the plaintiff to the extent of 5 decibel. Lordship has
Where is
got
the
it.
final degree?
Yes, your lordship. Thereafter, my lord, final decree has been passed following all the procedures of my lord, sketch map, my lord, inquiry, everything. And lordship kindly comes to page 33. Final decree engrossed with the stamp. Lordship has got it, page 33.
Yes.
Thereafter, decree has been drawn.
Where is the function provisional report showing that allotted portion? Yes,
My-
you are the plaintiff is the proof.
Yes, my father is the plaintiff.
Your father is the.
Yes, my lord, that is the, my lord admitted that. My lord, that's the five.
That is your. Page 29 is the commissioner's report.
Page 29 is the report.
Where is your allotted portion?
Land of the plaintiff, lordship will get it.
And what is this?
Lordship will get it, my lord,
It is
220.
free of, is for-
Yes, my lord, I am coming. My lord, there are some illegal constructions. Shops were there and the constructions made by the private respondent. Although, my lord, that is it in plot number
This demarcated portion is belongs to the defendant. I will respond.
to me.
So on the right hand side, land of safety, land of the defendant is there.
My land is in plot number 220, where my lord, my land declared with regard to 5 decibel.
Yes.
My lord, final decree drawn.
Yes.
So my lord, that is unchallenged decree.
Yes.
So my lord, my right title interest with regard to 5 decimal in plot number 220 has been declared.
Yes.
The defendant, what private
Where they are
respondent,
making construction.
they made the construction in plot number 231. Lordship will get from the sketch map, page 29.
Yes,
Plot
yes,
number
yes.
231 and 232, 233, which is adjacent to the plot number 220. Lordship,
31,
yes, your lordship.
31 and
231 and 232,
32.
yes. Adjacent to the plot number 220. What they did, they
Your plot is 220.
some of my plot is also there in 231. I am not on that because with regard to that civil partition
So what
suit
is
is
the
pending.
district plot
This
now?
is, my lord, their construction, what they have done, the construction, my lord, extended to plot number 220, where my declared land of 5 decimal is there. I made representations, that representations, lordship kindly comes to page 61, 62. My lord, at least a response has to be come from the commissioner lordship.
Yes.
I'm for the private respondents.
Lordship, if you take Lordship, their representation, which is at page 61, they're only alleging that the private respondents, they're trying to make the constructions, but they have not stated what constructions have been ordered. No.
Is the complaint made on March 2026?
If a lordship directs, then the commissioner will make inquiry, grant opportunity of hearing and pass reason order.
My humble submission is this, whether this writ petition is maintainable or not, because this is purely a civil dispute. Altogether, 3 civil suits are pending on the same issue. And this writ petition is, they have suppressed facts. It's hit by the principles of suppressio veri and suggestio facts, falsi. Now, I can draw your lordship's kind attention to different paras from their own averment and from their own document that has been annexed with the writ petition, that they are the decretal owner of 220. Now, construction is going on 231 and 232 plot numbers. Now, 220 and 231 and 232 are separate plots. How this writ petition will be maintained?
So according to you, you are carrying on in 231 and
232,
not in 220.
not in 220.
Directed to consider the petition after then both of you, if there is no construction on 220.
Now, please, I draw your lordship's kind attention to page 16. Para 2. That while said, while said Bhavakanta Roy was in possession of the land, transferred 5 decimal of land within specific boundary out of the 54 decimal of land in plot number 220, and executed a registered sale deed by number so and so dated 1967, and delivered possession to the same to the plaintiff. Now, that is the father of the petitioners. I draw your lordship kind attention to para 4 of the of that plain, page 17, that the land of plot 220 is the subject matter of the suit, that is the decretal suit. So decree was passed on 220 only.
That is what I am saying.
Yes.
I record your submission that you are construction.
Plus, this has to be recorded that there are 3 suits, civil suits pending before the jurisdiction. There is a police report. There is an inspection ordered passed by the court for inspection of the suit land. Now, how the jurisdiction of this honorable court comes in between? And there I have specific order from the civil court that the defendant should not disturb with my construction.
My lord, I have also said so.
My humble submission is this: there is a trend nowadays to invoke the jurisdiction of this court of equity. You know, what law cannot give legally has to be done in some other way. So I kindly note this submission also. Exemplary cost should be awarded to the legal aid service of this honorable court.
state is it.
Oh, sir, coffee खाओ अपना.
Coffee खाओ ना बाबा, coffee खाओगे क्या? Coffee खाओगे क्या?
Yes.
No, I'm not claiming. Neither the private respondents are claiming. Legal aid ke.
Offering him a cup of coffee.
Amrabad.
My lord, if I read out the My
You-
lord, if I read out the whole note that I have prepared now, this writ petition will be dismissed with cost today only. I'm obliged.
Is an instance of an owner of marketing exposure. Number two.
220, 220.
Now, the district of Darjeeling.
Jalpaiguri.
So, Jalpaiguri. The petitioner alleges, petitioner states that in the terms of a final decree passed in particular number. An area of about 5 decibels in plot number 220 has been allotted in favor of the father of the. You are getting by virtue of inheritance.
Yes, yes, yes.
Petition,
All the petitioners are there.
claims to be the the 5 decibels in plot number 220 from these are her
My lord, their logic.
from their fathers. Next, anything that the private respondent are making attempt making an attempt of they have started.
They have started law.
It's already come more or less completed.
Anything that the private respondents have started construction. Started initial construction on plot number 220. Petitioners have lodged a complaint. I later they will be charged of March. Before the commissioner during this particular function. The other advocate for the petitioner service, in spite of simple authority for this, the authorities of delivery corporation is still time and have not taken this case. Private respondent denies the allegation of the subjects. The private respondents are not carrying on any construction work on any portion of plot number 220. So the subjects that the construction work subjects to the private respondents are carrying on construction work in plot number 231 and 30.
Yes.
In plot numbers 231 and 232, strictly in accordance with the rights.
Moreover, yes, definitely. Moreover, in title suit number 152 of 2026, which has been filed against the petitioners, there is a,
You are final.
yes. There is a specific order. The defendants are restrained from interfering with the peaceful possession of the plaintiff and the raising of the construction.
Or in plot number? Plot number টা বলো।
31, 32?
ওখানে আমার
In further surveys, that since the petitioner was creating disturbances in the construction work of the private respondents on plot numbers 231 and 232 on the private respondents hearing, filed a suit being status number
152 of 2026.
152 of 2026 before the
Civil Judge Junior Division at Jalpaiguri.
civil junior commission at Jalpaiguri and on an
On,
application.
yes, rule 1 and 2.
Being moved from the garden.
By order dated to
As passed and ordered on
16/3/2026,
16/3/2026, restraining
the defendants
from creating any disturbances
and raising the construction
in the matter of raising construction on plot numbers 31 and 230. All are here for start surveys that necessary steps in accordance with law can be taken pursuant to the complaint lodged by the petitioner. Since an unauthorized since there is an allegation of unauthorized construction, we carried on in plot number 220 and the complaint has already been submitted with the authorities of this people. By directing the
Commissioner.
by directing the commissioner,
Issue number 3.
the not responded to consider the legal. And
এটা ডিপার্টমেন্ট এখানে না ডিপার্টমেন্ট
say by passing after passing of the of notice the petitioner, private respondents and any other person who will be affected by such inspection and dispose of the complaint by passing a receipt order after application the petitioner any other person will be affected by such or their so the entire exercise can be completed as expeditiously as positively within a period of 6 weeks.
8 weeks structure.
My lord, in the meantime, my lord, the construction will be done, lordship. So, my lord, some safeguard may kindly be
6
given
weeks.
to me.
In a period of 6 weeks, from the receipt of a sample copy of this order, let us take a copy of the representation petition to each other.
My lord, in the meantime, my lord,
My
the
lord, it
construction
is
will be done.
doctrine of least maintenance will come in between.
It's called intact.
Doctrine of least maintenance will come.
By that,
If
sir.
they do, let them invest, then illegal work will be demolished.
Yes.
My lord, just one line. It was my submission that the requisition has to be dismissed with cost to the legal department, legal aid service. Please, one line.
Mr. Palchani for the survey that the petitioner has suppressed a material facts and this to be dismissed with excel.
State is
To the legal aid service.
State is represented. State is represented.
Yes,
Grateful, your lord.
Obliged.
Grateful, your lord.
Seven.
I am for the
My lord,
state.
My lord,
I'm appearing for the petitioner in item number 7 on online, my lord.
My lord, can it be taken up on Monday? I'll take a lordship, my lord. I have received instructions, but I need certain clarifications, my lord. I have asked for the investigating officer to come, my lord.
The period of the Additions of, additions of this matters.
Grateful, my lord.
Grateful.
Item number 8.
আমরা আছি কেন
Yes.
তোমরা মিস করলো কি
Pending for pending
গ্রেটফুল মাই লর্ড নাম দেবে না মানে নামের বানানটা ঠিক লিখো এইটা জিআইটি পরিষ্কার করে লিখো এই হ্যান্ডরাইটিং কেউ পড়তে পারবে না এটাতে এজিপি লিখবে অ্যাডভোকেট ফর স্টেট লিখবে UNL JIT BHATTACHARJEE তোমারটা পরিষ্কার করে লিখো
subsequently there was a natural calamity.
ঠিক আছে ডিসপোজ নাম দিয়ে তো পয়সা
Punjab National Bank I have served.
I'm for the respondents.
You're for the bank.
I'm for the bank. I'm representing the respondents, my lord. I have gone through the petition only last night. I have received it, or that's online. Now there is a notification as violation number 5, the violation of which and compliance of the which that is petition is filed. There are other facts and notifications, my lord, that needs to be brought on record, my lord, for the, and I have instructions from the bank that they'll be providing me as soon as possible. Within the, this, if the same this treatment can be heard any day next week, my lord, then I'll be able to come up with a written response to it by way of an affidavit before your lordship to consider.
Yes, yes. I am a MSME unit. My exam registration certificate is understood case number P1. Now, lordship, after taking the loan, lordship, I started orchid. But unfortunately, last year, your lordship, because there was a devastating flood in North Bengal, my entire orchid was taken. Now, again, to generate funds out of it, I needed fresh sanction, fresh loan, or I requested the bank authorities to restructure the thing, restructure the loan application. And my at page number 18, annexure P2 is my application for restructuring.
What happened to that?
It was rejected by the annexure P3, page 20. It was rejected by the chief manager of Punjab National Bank. My issue is that there are several statutory guidelines by the Reserve Bank of India that while citing the issue, it has to be done by a committee. The chief manager of the Punjab National Bank, he himself cannot do it. And the guidelines have not been followed, not been considered at all. I am only praying for the lordship, let this order be set aside, reverted back to the bank to decide the issue afresh in terms of the guidelines prescribed by the Reserve Bank of India. My first, yes, first.
Where is that? It has to be decided by the committee. Please show me.
Yes, yes. My first lordship, and it takes. And it takes page 41, P5. This is the framework for revival and rehabilitation of micro, small, and medium enterprise. This is the notification, and from page number 43, the regulation starts. It's under the caption framework for revival and rehabilitation of micro, small, and medium enterprise. The lordship kindly directly comes to page number 44, clause number 3. Committees for stressed micro, small, and medium enterprise. In order to enable faster resolution of stresses in an MSME account, every bank shall form committee for stressed micro, small, medium enterprise as per the following arrangements. 3.3 is the composition of the committee. What will be the composition?
Yes, sir. What you say? As per this, it has to be decided by the committee. So now it appears that it has to be decided by the chief manager.
My lord, I have the instructions. My lord, that this was referred to the committee also, whether or not official. I am not. I will come up with all the instructions if your lordship directs me.
Because this says, notification says it has to be decided by a committee. If this was not decided by the committee, I directly committee to take a decision without going to the very. Because it appears this decision was not taken by the committee, it was only by the chief manager.
Even if assuming what he says that it was
But
sent to the committee,
there are-
nothing, no reflection.
There are few more things. For example, with this account, my lord, there is a linked account also, which is a non-performing asset also, man. There are few things that needs to be
What
considered. my
accounts
lord.
they are linking to the.
I have
No-
received, this is the first day of hearing, my lord. I have received the brief only last night. My lord gives him only 1 day. 1 day I will come up with all the instructions. Any day next week, any day next week.
Can, raise for the information, enable me to contact with this. Yes, when do you want to come back?
My lord,
When do you want to come back?
my lord, any day
When do
next
you
week, my
want?
lord. My lord, Wednesday, Tuesday, Friday, anything.
Wednesday. Yes. Next.
Much of it.
Just one
That's the
question.
Item number 10.
Same color and for the petition. Lordship,
Yes, what is this?
Lordship, this matter is pertaining to Lordship. I own a flat in the C apartment, Lordship. Now I purchase one.
It's a lot of appearing.
Essentially.
Malnotations.
Siliguri municipal. Yes.
Lordship. Lordship, then I purchased one garage. Now what happened in Lordship is that the on the garage, the residential garage. On the same, no Lordship. Construction has been made on that garage. What happened is that Lordship, the residential of this building started keep vehicle on that garage. So to prevent that Lordship, I made a small 30 to 40 square meter structure over there. Lordship, in that this as per according to the notice published by the Urban Development Municipal Affairs Department, that is permissible subject to payment made. Lordship, now on that regard, I make a representation before the authority, Lordship. So
Where is that?
the representation in page number 16, P3.
Yes.
We shall consider the representation, my lord.
The petitioner. Is that the prayer of the petitioner? Permit. Make certain internal deviations in the back side of the garage.
Garage, Lordship.
Back side of the garage. That of the central building stand dated 9th December 20. You see the year.
Yes, Lordship.
Year is 2015.
2015, my lord.
2015, Lordship. It has been wrongly inserted.
Large advocate agreement that decision on such critical conditions are taken and communicated all the to be acting as being
Consider in terms of this.
by
Respondent number 2. Respondent.
Commissioner.
22.
Yes, possible. Positive have a period of 6 days. Is in adverse transport is market rated on the same. An opportunity of it shall be according
My lord, one indulgence before your lordship, my lord, kindly mention the notification, my lord. Miss, the notification is stated in the second paragraph as per the UTMA minor deviation rules number 889/UTMA. Miss,
15011.
that is
Lordship, Annexure P2.
Annexure P2, page number 16. 16 you likhe the.
The notification is there.
Yes.
Yes, Lordship.
The notification is annexed, my lord. My deeply obliged, deeply obliged.
Item number 11.
Lordship, item number 11, the service has not been effected yet. And Lordship, when not aware of the matter, but the advocate on record just instructed that the pad in later pad it was cited the date on Monday. So Lordship on that ground, Monday. It has been wrongly inserted that Monday. So Lordship kindly keep the matter on Monday.
This can be disposed of. Second, I have my lordship for a moment on page 49. 49 is a representation that they have made. They say that the land was acquired in the 3A notification, 3D notification, their name was. They say that the land was acquired, but their name was not there in the notification. There is rival contention whether the land belonged to them or not. Now, as per the National Highways Act. So, as per the National Highways Act, there is a reference 3H4. Award has been passed, but nobody has been, amount has not been disbursed to anyone. So what we can do is, we can ask the authorities in terms of 3H4 of the National Highways. As per the entitlement, 3H4, let the district judge decide it. Whoever will place the case there before the district judge will get the compulsion.
Consider Lordship.
Page 49, 6th of January 2026. The competent authority, Lord, should be the Special Land Acquisition Authority. Officer, CALA, Competent Authority Land Acquisition. Special Land Acquisition. No, Special Land Acquisition. Yes, ma'am. Yes, ma'am. Yes, ma'am. As per 3H4.
Yes, Lordship.
So then you have to.
3H4.
Yes.
As per 3H4, let it be referred to the district judge. They will stake their claim there. Whoever is entitled will get it.
थैंक यू हमको ब्रीफ तो था दे दिया हम स्कैन कर लेंगे हाँ
774/3141
मेरा ब्रीफ ला दूंगी आप कर लेना हम स्कैन कर लेंगे खाली ये दे दो ना ओनली हमको नेक्स्ट भी नहीं चाहिए पिटीशन एंड नेक्स्ट द बिल नेक्स्ट मैटर भैया प्लीज यहाँ से हिलना नहीं 12 नंबर है उसको अटकाओ जैसे भी करके मेरा दिमाग खराब हो रहा है 68 पिटीशनर से कुछ ऐसा ही बोलो कल जैसा
4 laning and widening of 31D. D.
क्यों हम वो इधर के लिए गया है थोड़ा भर के
The dispute is rival contention is there with regard to the ownership of the land. He claims it to be his land by way of inheritance. Yes.
States that the
Predecessor in interest of one
plot was recorded in the name of their predecessor in interest, namely Calcutta or
Barua.
Petitioner alleges that
तुम जाओ ना,
petitioner
तुम जाओ क्योंकि स्टेट में तो नहीं है, पास तो सभी होगा, तुम जाओ वहाँ पे।
and is entitled to receive compensation for acquisition of the aforesaid plot of land, but no compensation has been disbursed in favor of the state. The petitioner submitted a representation before various authorities, including the special land acquisition officer and competent authority under the National Highways Act 19, praying for giving for an order directing for disbursement of the compensation in their favor on verification of the land record.
सर हमारा एक्सपीरियंस फाइल करते हैं अल्लाह आ गया पता दो कंपटीशन फाइल कर लेता कितना पेज है इसमें 1,500 पेज होगा हाँ 150 करके
several persons claim to be interested in the amount of compensation by the government in respect of the state. Submits that unless the dispute has to the apportionment of the amount
Claim and apportionment. Claim and apportionment, because who is possessing which portion is also.
Is decided by the concerned authority. The consent form cannot be disbursed for any person. Section 3H, which Packet 4 of the Directive Act states that in the dispute arises as to the amount or any part thereof, or any person whom the same or any part thereof is paid from a competent authority shall therefore receive the single of his principles of original consideration within the limits of the land is stated. After going to the representation, has arisen to the apportionment of the amount or any part thereof or any person says or any part thereof is paid. So such a dispute squarely falls within the scope and activity of rules of the National Highways Act 1956. So there are the successors and supposed to by directing the student and the computing auditing under the next slide fourth respond
Prefer a reference case.
Take steps in accordance with the provisions of section 3H to the bracket 4 of the 1956 Act. On the basis of the representation dated 6th of January 2026. exercise by the correspondent shall be done
2 months.
Reference was
No, the amount also has to be deposited there with the, no, the reference goes along with the amount.
yes.
1 month.
ठीक है हो जाता
1 month. No,
Yes,
the amount
we
has
have-
been given by them. We have, no,
है no not to me
From the receipt of server
बस रुकिए रुकिए कहाँ भाग रहे हैं भाई टेंशन है बहुत मैं लेके आती हूँ
this is the size of the petition.
No, not required, Millard. Only the volume 1 and 2 will do.
Volume 1 and 10.
Volume 1 and volume 10. No substance, nothing. Only volume, less substance. শুধু প্রথম আর নিচেরটা দিন না। Millard, I'll just place in brief. Millard, our honorable court has already considered this matter, covered by a division bench also. Millard, these are all, Millard, they are all the petitioners, all court fees paid. They are, Millard, teachers who were appointed in the appointment letters were handed up in 2013. But the recruit appointed in Millard primary schools within the GTA region. Appointment letters handed up in 2013, recruitment process completed in 2002. 2002, interview held in 2002. According to their own subsequent notification and exchanges in between the GTA and the state, Millard would find that the panel was already prepared in 2002. Subsequently, they modified the panel to the extent possible to bring it in compliance with the primary teacher recruitment rules 2011 and subsequently handed over the letters of appointment in 2013. We are only paying Millard notional benefit for the purpose of calculation of pension and other retirement benefits with effect from 2000. We are about to retire. Within 1 or 2 years, they are all retiring. And Millard, this has been considered by this court. And Millard, these benefits have been granted. This is Millard in short. Now, Millard, first, Millard, if I just take your lordships from the documents. Millard, I'll just first place the orders, Millard, of this court first. Then, Millard, I'll just bring back your lordship to the documents. Yes, Millard, kindly 9:33.
Before the membership, may kindly have a look at the prayer clause. Prayer clause, prayer B and C at page 43. He wants to have notional seniority.
Sir, I'm not pressing that. That is not required. I'm only paying notional benefit, Millard, to the extent of calculation of pension and Millard retirement benefits. Today, Millard, 2 years prior to retirement, Millard, there is no question of seniority, Millard. I'm not pressing that also. Only, Millard, for the purpose of calculation of retirement benefits. Millard will just take this, the order, Millard, all the orders, which have, Millard, several coordinate benches have passed from time to time. Division benches also. That is one of the. No, those orders were never been challenged. Division bench has been relied upon. Yes. By the coordinate bench. Millard would first take WPA 2671. Petitioner's name is.
He never does that. He never does that.
Millard, I can. All the orders are more or less same. Millard,
Yes.
Millard, I can give him all the copies and come back tomorrow. No difficulty if he wants to go through.
All the orders are similar.
Similar.
दिखाओ तो सुमन भाई, हाँ ये वाला के बाद से तो सारा प्रॉब्लम स्टार्ट हो रहा है।
Otherwise, you will not be entitled to pension.
We will not be entitled to pension. Yes, and this.
No, minimum qualified service would be there. 2013, the appointment letters were issued. And they are still in service.
So it is क्या
10 years. Lords, I do not have a problem with granting notional
Only
10 year
notional.
for the purpose of pension.
But we are only.
But the prayer
only
clause,
notional.
the prayer clause says notional seniority, notional seniority.
I am giving up that.
Speaking of that, only restricting is with regard to the that date.
Only for the purpose of calculation of
Yes.
Only for the purpose of calculation.
Qualifying service.
That's all I'm
minimum,
praying for.
not even for minimum qualifying service. Only for the purpose of calculation of the last basic pay that would be there.
Yes. Only
We will
only
consider
that
and
much.
we will come back tomorrow. I will just talk with the authorities once, because I was of the opinion looking after the prayer clause that they are seeking for seniority. That cannot be done because the Supreme Court judgment is staring at their face.
Representation is there.
Malus.
No, Millard, with well, only difficulty with the representation is Millard, these petitioners, 69 of them are before your lordship. Now the representation was in the nature of a mass petition, signed by one group, another representation by another group. Substance is the same. So Millard, in that event, Millard, allow us, these petitioners, to prefer a fresh.
No, I will make it simple for them. Let me have the instruction from the authorities. If they want this only for the calculation of the pension, then Lord, that is something that
Millard can pass a mandatory order.
But seniority cannot
Instead
is not
of
something that can be done.
sending it for Millard consideration, if Mr. Mishra consents after considering the order. Correct.
A comprehensive representation, let them submit.
Right.
And in one case, I think there is a 2019 also. Now, how he joined in 2019?
So there might be from case to case, there might be one or two that mandatory will be a problem. So in case I should be waiting to file a representation, they can consider that a case to case basis.
Right, Millard. Right.
Because they might, one or two cases.
No, Millard, so far as Millard, these petitioners before your lordship are concerned, Millard, from at para 10 of my writ petition, Millard, I have given their date of joining, all in Millard, March 2023, 2030.
Page 20 to this, page 20 to serial number 8, 2019. Page 22, serial number 8.
No, that is a typographical letter. There are documents. For all the petitioners, there are documents. All 2013.
For that,
Let them make a comprehensive representation. It will be considered. That would
No difficulty. Millard, allow us to make a comprehensive representation within 7 days. Let them consider, but Millard, kindly take note of the judgments. They should consider it in light of this, so that Millard, further round of litigation can be avoided.
And also that they are not pressing for notional seniority.
only I will record
Only,
because there is the submitting of press notice.
yes.
Only with regard to notional
10 year of service calculation from 2002
date of joining.
to 2030.
Yes, the date of joining shall be considered for the purpose of calculation of the pension.
Yes.
Date of joining is 2013. They are claiming it from 2002 when the advertisement was.
Yes.
Not the appointment.
Malorship.
Yes.
Date of joining the institution.
Yes.
So Millard, in 2002, the panel was prepared, but not published. So exact date in 2002 is not even aware we are.
You are claiming notional that date from the
Preparation of the panel in 2002 to 2030.
He is claiming from 2002. That is the problem. That is an issue.
Yes, that is why please consider.
Millard,
That is why let
Millard,
It's not a problem.
2013, the
2013
appointment
problem.
minutes were handed up.
Also, that is
Never a problem.
yes. Because they want
Millard, prayer B.
Milord, kindly see sprayer B. Yes.
ये वाला नहीं हमको ढूंढ रहे थे
Yes.
ये लो
No, we have joined in 2013 because unless they hand up the appointment letter, we could not have joined. But the recruitment process was completed in 2002.
Now,
And
whether they are
thereafter-
entitled or not, that is also an
Thereafter,
issue.
sir, just allow me to
Yes, sir.
place my case, Milord. Milord, from 2002, for reasons not attributable to me, the recruitment process was held up till 2013. And all the judgments, Milord, would find the ratio is when for reasons not attributable to the employee, if the recruitment process is held up. Yes, that's the standard. Yes. I have already handed up, Milord.
And this one. That what.
DPSC for litigations, etc. Yes, Milord. This is the division bench and Milord. And Milord, there is another judgment also on the similar lines by Justice Dipankar Dutt, sitting with Justice Pratik Prakash Banerjee. Ratio is the same. Correct. Yes, that is the crux of the matter. The ratio of all the orders.
Date of right to the appointment.
Yes.
Date of right to the appointment. Where does this statement that from the panel?
Panel is in 2012, Milord, 2002. Milord would take भैया एक बार वो वाला दीजिए ना जो पहली वाला था फर्स्ट वन
Appointed.
ये नहीं Milord, kindly takes WPA 2671, the order passed in WPA 2671, considering Justice Standards Division Bench. Nando Kishore Tamang. This petitioner is from the same equally similarly circumstance petitioner. Milord, kindly takes WPA 2671.
Yes.
Here also, Milord, the representation was directed to be considered.
Yes.
And Milord, 2002 recruitment process.
Not
No,
that.
the specific date was not given because of the reason in 2002 when the panel was prepared, they did not publish it. They published it in 2013 after making modifications in the panel.
Better than to file a representation.
Yes, no.
Date. That has to be taken.
That has to be taken into consideration. That date.
Seniority is not something they are pressing, they are only pressing for yes.
Milord, in Nando Kishore Tamang, Milord, the facts are recorded. Similarly, circumstance petitioner.
Synopsis.
But can the synopsis be relied upon?
This is correct.
Correct.
Synopsis is correct.
Process was legislated.
2002.
Process for the purpose of appointment of primary teachers.
Primary teacher.
Primary school teachers of the GT.
Yes, Milord, I will.
The petitioners participated in a recruitment process initiated by DGH.
The then DGHC,
Then
Darjeeling Gorkha Hill Council, will subsequently
By EL, Darjeeling Gorkha Hill Council. That was what DGHC. All capitals. Now, Gorkhaland Territorial Administration was brought in the year 2002. the petitioner alleges that though
Written examination, interview, then preparation of panel. 2002, all complete.
Petitioner alleges that though the written examination for interview
And interview.
interview was completed in the year 2002. But the panel was not formally published. Immediately,
Panel was prepared according to their own admission,
published as
not published.
and the panel was prepared.
Yes,
But the same was not formally published till 2013.
2013.
The date.
2013, Millard, it was published on Millard.
Don't have the exact date.
We have Millard, 8th November 2013.
Till 8th of November 2025.
Yes.
So, after publication, the panel, the petitioners issued the appointment letters in the sometimes in the year 2013, and they and immediately thereafter joined different institutions under the control and administration of KTA in the year 25.
Yes.
The petitioners, all of them are about to retire.
All of them are about to retire.
The petitioners are about to retire from their services on attaining the age of superannuation. Within a year,
Within couple of years, Millard, some,
couple of years.
yes. इस साल में भी तो रिटायर कर रहे हैं 26 में. There are some petitioners who are retiring this year even.
That's what it's.
Yes.
So those are the actually from the particular service. That the BA issuing the appointment letters in favor of the petitions is not attributable to the petitioners. So the delay commission only for the only on account of some procedural formalities to be completed by the
It was because of administrative reason, the hill area got segregated, mulched.
Further surveys, due to the delay in issuing the appointment letters, several other conditions. They will not be entitled to the pension benefits at the rate that they should have, that they should be getting if they were appointed immediately after completion of the intern. And there was a case that the petitioners, there was a case that the date of completion submits that the submits that the qualifying period of service counted from the date of approval of right to appointment. By giving notional anything from the purpose of calculation.
And he is not pressing upon notional.
Subjects. Our subjects. That comprehensive presentations either in traditional stage where have not been submitted, though some mass petitions by several students expected teachers have been submitted to the learning assistant subjects that the
Number one, there was a change in administrative authority from DGSC to GTA. That was the one of the reasons. Second is they haven't provided any actual service from 2002 to 2013.
is that the education has gained social seniority from the date of other subjects that such welfare cannot be extended to further subjects that are not rendered any service,
Actual service.
not rendered actual service
From 2002 till 2013.
letters that
And when they have accepted the appointment letter in 2013, they did it without any.
the further subjects that since the commissioners have been appointed only the year 2013, they cannot take any benefit from further subjects that issuing their appointment letters was on account of administrative
Change of administrative authority.
change of
Administrative authority from DGHC to GTA.
from DGHC. In reply, Mr. Ghosh started upon instructions that the petitioners pressing their claim regarding the social seniority but is pressing the claim for solicitation benefit only for the purpose of calculation of pension. Such submission of Mr. Ghosh is pressing on the top. Support such contention, Mr. Ghosh is plans upon petition make decisions. Orders and order passed on 11 by law. In case of state of festival and others and order dated October 31
काम करवाना सारा होता है. फाइनल में बज रहा है।
हम वही सोच रहे हैं, ऐसा हो रहा है। कौन सी दिक्कत है?
कोई पकड़ा गया आज? जीता तो सब है, पकड़ा कोई नहीं जाता है।
First, I think, under section 19 of the RTA and Fellowship, again, praying for filling the answer papers, which they did not consider. In fellowship, is careful.
Yes. Yes. What is this report? What is this report?
This is a report from ASQ Sholo.
Yes, what does the report say?
Says ASQ Sholo has never filed any RPI application for this.
Is what do you say to this? That she wants the answer scripts to be, a copy of the answer scripts to be given to her.
Already informed the petitioner regarding the marks.
Yes. Yes, yes. Where is the provision for supply of this answer scripts? What do you do? If the answer scripts you wanted state by state, you wanted the backup marks has now been given. Where is your allegation that that's not the correct marks? Please show me from the from your pleadings.
She was not satisfied with the.
Where is that? Where is that statement? Yes. Where have you said that she is not satisfied with the marks?
The last slide, the first paragraph, last slide.
Which page? 40. Yes. First paragraph. Yes.
Is not satisfied from the marks she's shown to have received in the written.
Yes.
Why not she is a very relatively student of class. And we see that is P3, she page number 21 onwards.
Yes. 21.
She is BA degree holder from the University also. That cleared the elementary education with the good marks.
What is the marks? You have the marks obtained by her in any one of the examinations.
It's 20 hours.
Page 20.
21.
21.
She
Yes. One thing can be done, I can direct the first appeal to be disposed of. Because Right to Information Act, that information has not been furnished. You have prepared a first appeal. So I'm directing the respondent number 4. You have prepared a first appeal. Where is that? Page
44.
44. District Program Officer. No. Appellate Authority is District Program Officer. The petitioner alleges that that being agreed by the non-supply of reply to the application under Section 6 of the Right to Information Act 2005, the petitioner has approached the first appellate authority by preferring an appeal under section 19 of the Right to Information Act by an appeal petition dated February 20, 2026. So the learned advocate agreeing for the petitioner submits that no decision has been communicated by the appellate authority till date. To start paragraph, heard the learned advocate for the state. To start paragraph, the district program officer, Jalpaiguri Sodor ICDS project, being the which respondent. Being the second respondent. No, that is the district magistrate. District program officer, please simply being the added respondent is directed to dispose of the appeal filed by the petitioner under section 19 of the Right to Information Act 2005 as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a circular copy of this order, together with a copy of the appeal petition dated 20th of February 2026. So, on the prayer of the learned advocate for the petitioner, he is granted the learned advocate on behalf of the petitioner to add the district program officer Jalpaiguri Sodor ICDS project as the party responding in this petition, Guarana full stop. Next. Yes. Yes, who is appearing? Why? On the prayer of the learned advocate for the petitioner, list this matter in the next view. Yes, next. Item number 16. Yes.
At about 2.5 p.m. The petitioner is a traffic rider number. I know that's a motorcycle service he provides transport. On the 22nd of June 2026, at about 2:05 p.m., he was picked up from a barber shop. From there around till 6:05 p.m., there is a period of rest. That's the kind of rest. He was unlawfully taken from one police station to another, and thereafter finally taken up to Mohanda Bridge, where allegedly 268 grams of brown sugar recovered from his motorcycles underneath the seat of his motorcycle. If you remember, date of arrest is on 22nd. As per section 48 of the PNS, the county of arrest is to be communicated to relatives. So that has been done after 4 days. No explanation regarding the same and not served. The personnel came to the house of the relatives and they just affixed the notice on the wall mirror. There is a video to that extent that requested the relative to get certifications to I'll place it for the floor. I am on the contact of the respondent number 6. I've named him in person. This particular remote charge is this particular respondent. There have been several cases.
Have you served upon the respondent number 6?
Yes.
Mr. Vadajaji, who is representing the respondent number 6?
He has been named a personal capacity number 5. Yes. Otherwise, the state has been served.
But he has been served. He's one of the, maybe he has been named as a by name. He has been included, but you have to inform him. Yes. So file a report. The officer in charge, Bhaktinagar Police Station, is directed to file a report in the form in the form of an affidavit with regard to the allegations contained in this petition. To start, let such report in the form of an affidavit be filed on or before July 29, 2026. To start, list this matter on July 29, 2026. You are getting this first chance. Second chance cannot be above first chance. Yes, next.
My lord, I'm appearing online in item number 17 for the state.
Yes. Second round, why? Yes. So here also an order has been passed.
Yes,
In your matter.
my lord, yesterday in a similar case, an order was passed by my lordships.
No, in the petitioner's matter, an earlier order has been passed. Where is that? One zero four. Yes. Where is your representation? Representation date is same. All right. Come on.
The post was error was it was written as postdoc program assistant. Page number 105, balance 7. Last time, postdoc program assistant.
That order I cannot correct. That order I cannot correct. Junior programmers. No, it doesn't correct it. Why? Junior program, oh, it has been made junior program assistant. Petition file WPA 332 of 2026, alleging inaction on the part of the respondent authorities in not considering and disposing of the petitioner's representation in terms of para 47 of the judgment delivered by the Honorable Supreme Court in Civil Appeal number 004800/2025, State of West Bengal versus Bush 0048/00/2025, State of West Bengal versus Bulshaki Bhattacharya Chatterjee and others, dated 3rd of April 2025. The learned advocate appealing for the petitioner submits that the petitioner was appointed to the post of junior program officer under MGNREGA under the fifth respondent filed memo number 1310/MGNREGA dated 16th of March 2017. The petitioner states that she is eligible and has also fulfilled the requisite criteria as per the observations made by the Honorable Supreme Court in paragraph 47 of the judgment dated 3rd of April 2025, and claims to have submitted a representation before the fifth respondent seeking resumption to the post of junior program officer under NGNREGA Alipurduar. Alleging inaction on the part of the respondent authorities, the petitioner filed WPA 332 of 2026. A courted bench by an order dated 17th of March 2026 directed the respondent number 3 therein to consider and decide the petitioner's representation/application, including the representation dated 21/4/2025, in accordance with law and in light of paragraph 47 of the judgment of the Honorable Supreme Court within a specified time frame. So the learned advocate agreeing for the petitioner submits that in spite of expiry of the stipulated period, the respondent authority has not communicated its decision to the petitioner till date. To start, the learned advocate agreeing for the state submits that the learned advocate agreeing for the third respondent submits that the reasoned order shall be communicated to the petitioner within a period of 2 weeks from date. The third paragraph, such submission of the learned advocate for the third respondent is placed on record. To start with the light paragraph, in the light of the submissions made by the learned advocate for the respective parties, this petition stands disposed of by directing the Commissioner of Manrega, Panchayat and Rural Development Department to pass a result and speaking order on the petitioner's representation dated April 21, 2025, and communicate the same to the petitioner as expeditiously as possible, but positively on or before August 17, 2026. It is however made clear that this court has not expressed any opinion on the merits of the claim of the petitioner, and all points are left open to be decided by the same authority in accordance with law. Yes, next.
Grateful, my lords.
Yes. Isaiah disposed of. Yes, next.
Item number 19, my lord. This is my affidavit of service.
Yes, what is this cover?
My lord, this is the second round of litigation, my lord. The petitioners were the teachers, retired teachers, my lord. Subsequent to the superannuation, they were appointed as guest teacher in a specific government model school, my lord. And after their appointment, my lord, even in their appointment letter also, their remuneration was fixed in terms of a specific government order, my lord. However, they were not getting that government order, so they filed one writ petition previously. The order of the writ petition is annexed at page number 24, my lord. A coordinate bench of this court, my lord Justice Joyshan Gupta, directed that, observed that their remuneration were being paid by violation of that specific government order, my lord. However, for the ends of justice, directed the Commissioner of School Education to consider the writ petition as a representation and directed to pass the reasoned order, my lord. My lord, now kindly come to page number 26. This is the order passed by the Commissioner of School Education in terms of my writ petition, my lord. Relevant? No, my lord. My prayer was allowed, my lord. Kindly come to page number 27, the relevant portion. My lord, in the said order, they stated that from the date of my appointment, this benefit of notification is to be given to me. They admitted it, my lord, at page number 27. Kindly come once, my lord.
Yes.
However, my lord, I have been given the benefit of this GO after the result of my writ petition, my lord. So I have, that means a huge amount of area has already made due, my lord. Though they have admitted that I am entitled to get the benefit of Geo from the very first day of my employment as guest teacher, my lord. At page number 27, my lord, kindly come. Yes, my lord. From the date of re-employment. But I have given the benefit after the result of my writ petition, my lord.
So the result of your writ petition means after 24th of July, with effect from 24th of July 2024.
My lord, I got this from February 2025, my lord, after my writ petition. So of my WPA 1430, my lord.
1420, 1430 was disposed of on 24th of July 2024.
Yes, thereafter they consider my representation after passing of this order. That is on 21st November 2024, they passed this order.
Yes.
And subsequently they have given me from the month of,
Which date they have given you?
from February 2025, my lord.
Of February 2025.
My lord.
You are entitled
From the very first day of my
the date.
date of, my lord, I didn't understand date of my
Employment, what is the date of your new employment?
my date of joining. Yes, my lord, I have mentioned
What
it.
is that?
From page number, it's from page number 17, my lord, from 21/11/2021. My lord, kindly come to.
Your date of re-employment, where is it stated there?
In my petition, I have mentioned, my lord. I'm showing it, my lord.
Employment 2021, yes. Page
Yes.
17.
From page 17. At the bottom, it has been written, my lord.
Yes.
Now, subsequently, my lord, I issued a notice to the SDO, my lord, because in the committee of my appointment, he was a member, my lord. Now, my lord, kindly come to page number 30.
Yes.
Now, SDO, after receiving my letter, my lord, my legal notice, SDO issued a letter to the Deputy Director of School Education praying for releasing of this fund, my lord, 24,21,267. But till date, this fund has not been given to us.
Lordship, as we got to know that for commission, there is a separate panel, Lordship. State is respondent number 2, Lordship.
State appeared, my lord, in all previous cases.
But today we got to know that there is separate panel, Lordship.
Commissioner of School Education.
Yes. And
Maybe a separate panel.
but
It's an admitted claim, my lord.
his prayer is
Who is appearing in this education matters? Commissioner of School Education, state represents.
but some of the officer of the state said that no, there is a separate panel, Lordship, and we
You
don't
are
have the
in
number
the
of the
state.
commissioner of.
You have served.
Yes, my lord.
Yes,
To the state.
Somebody is appearing, I am directing this fund to be released.
Obliged, lordship.
Lordship.
And will not kindly issue interest, my lord, because from 2021 they have admitted, but till date they have not paid, my lord.
Funds from.
Obliged, lordship.
अपने लेवल पे नहीं है, इसका नंबर कौन पहचानने है, कोशिश करने में ये बहुत सारे केसेस में बात होता है। ठीक है।
Which paragraph you have stated with regard to your BA employment?
Yes, my lord, I am showing it. Well, from at page number 3, paragraph number 3.
Page number 3, paragraph number
3.
Petitioner who was who retired as a teacher, who retired from the post of a teacher in you have the higher secondary school.
Yes.
In a higher secondary school was subsequently appointed on
My lord, 5 teachers are there, my lord. 5, yes, my lord. 5 teachers.
Petitioners who are the teachers, who are the retired teachers of various high and higher secondary government aided schools. Now their appointment dates are all re-employment dates. are
Same,
also
same.
different.
Same date. We all were appointed on same date.
Were appointed on purely temporary basis to officiate in the post of guest teacher in various government model schools
Same government model school, my lord.
in various in government model school Khoribari. Pursuant to a memo dated 21/12/2021. The grievance of the petitioner is that though the respondent authorities where is that order where it has been said that you are entitled to that.
At page number 27, the relevant portion is there, my lord.
To the Commissioner of School Education, West Bengal, I order dated 21/11/2024 allowed the prayer of the petitioner for the benefits as per the provisions of GO number 6742-F with the bracket P2 bracket dated 2/12/2019 from the date of re-employment as guest teacher at the said school, the benefits of the said circular has been extended to the petitioners only from February 2025 and not from the date of their re-employment.
Oh, bless lordship.
That is on 21/12/2021. The petitioners thereafter approached the concerned subdivision officer for making payment of the alien amount in terms of the said circular with effect from the date of their employment. The learned advocate appealing for the petitioner submits that the concerned subdivision officer by memo dated 17/11/2025 requested the Deputy Director of School Education to make necessary arrangement for allotment of fund, but no amount has been paid to the petitioners with regard to the area amount till date. So, seeing on junior government advocate appears for the state. She submits that there is a separate panel of advocates who are representing the school education department. Paragraph affidavit of service filed in court today is taken on record. The learned advocate appealing for the petitioner submits that the Commissioner of School Education West Bengal has been and the Deputy Director of School Education has been duly served. However, such respondents are not being represented before this court. Paragraph since the Commissioner of School Education has already decided in favor of the petitioners that they are entitled to the benefits of the memo dated memo dated 2/12.
2/12/2019.
Memo dated 2/12/2019 with effect from the date of their re-employment, comma. This code directs the respondent authorities to release the area payment in favor of the commissioners as expeditiously as possible, but positively within a period of 6 weeks from the date of receipt of a server copy of this order, together with a copy of the representation. Together with the server copy of this order. So, sir, the area payment together with interest at the rate of 8% per annum, calculated from the date of re-employment till the date of making such payment. So, we take action for them. So it is now made clear that in the event the payment of the area payment is not disbursed in favor of the petitioner within the time limit mentioned herein before, the said amount shall carry a further interest of 2% on the said amount.
And 10%
Next.
Obliged lordship.
Yes. Item number 20. Yes.
Melody 20, I am for the petitioner. This is the petitioner being the headmaster of a higher secondary school. She is claiming 3% additional increment for
Additional increment.
Yes, my lord.
Additional increment. 3% additional increment disposed of tax.
No, my lord. I have only, my lord, the one thing, my lord, there is a dispute. I have seen my lord's order, my lord, but in this case, petitioner did not make any representation. My lord, kindly, my lord, grant liberty to make a comprehensive representation before the Commissioner of School Education. Then, my lord, the operating remaining part of your lordship's order.
After the order is passed, you want the representation to be made.
No, my lord, this is the after setting aside 27 circular. My lord, the DI is duty bound to repeat the pay scale upon granting additional. Only my lord, this change the lordship's paragraph, my lord, kindly, my lord,
paragraph.
My lord's order.
You have the copy of the order, sir?
I have seen your
Here your prayer has been rejected.
Third paragraph may be changed.
20. Yes, where is the order?
This is the Amrita Sinha justice.
The format order, the other 5 coordinate bench, there will be no change. If the lordship permit, the order can be passed.
Here it has been rejected. Your prayer has been rejected.
No. DI has not rejected. DI denied to repeat the pay scale. No, DI did not reject any application. Since the commissioner is taking up the matter in care, 3% additional increment, other coordinate bench direct the commissioner to take a decision.
Yes, I have also directed that. So what do you want?
My lord, I am, my lord, kindly grant liberty to the petitioner to make a representation before the commissioner. My lord's order, second page, paragraph 3, my lord, can be changed. Your lordship's order, my lord, the 903 of 2026. Order has been passed 20th July. My lord's, my lord, in another case, Subroto Chakraborty.
July, yes, order. Who has not brought that order?
Your lordship's, my lord,
Interim service finding for today is taken on record. The petitioner claims to have joined the post of headmaster. On headmaster, you have joined when?
On 18 July 2019.
On 18th of July 2019. The petitioner, the concerned institution was upgraded to a higher secondary institution on
3rd August 2011.
On 3rd of August 2011.
That has not been annexed.
Yes, stated that the petitioner seeks additional increment on account of his joining the upgraded school in terms of the memorandum number 30-AC within bracket B/5 capital B -1/2009 dated 10th of February 2010 and the government order number 1003-AC within bracket S/5P-129/12 dated 4th of December 2014. The government order dated 4th of December 2014 was withdrawn by a subsequent order of the Joint Secretary, Secretary within brackets, School Education Department Secretary Branch by GO dated 22nd of March 2017. It is not in dispute that the memo dated 22nd of March 2017 has been set aside by a coordinate bench of the scope in WPA 6217 of 2021 an order dated 15th of January 2024. The petitioner Mr. Jana Lanet, advocate appealing for the petitioner, submits that the petitioners have not yet applied for release of the additional increment at the rate of 3%. So, he pays for liberty to submit a representation in that regard. So, paragraph, heard the Lanet advocate for the state. Paragraph, in light of the submissions made by the Lanet advocates to the respective parties, by giving liberty to the petitioner to apply before the Commissioner of School Education West Bengal for grant of additional increment in terms of the memorandum dated 10th of February 2010 and 4th of December 2014. If such a representation is submitted, the respondent authority shall consider and dispose of such representation strictly in accordance with law in the light of the decisions passed by this Honorable Court on such issue. If the authority decides in favor of the petitioner, all consequential steps thereafter shall be taken in accordance with law as expeditiously as possible. Yes, next, call the next matter.
Matter number 21.
Yes.
Lord, I am for the petition.
Yes. This is 21.
Huh? Lord, the deceased husband of the petitioner was a dealer of fair price shop. After fair price shop, Milord, subsequently after his death, Milord, the first wife of the husband of the petitioner.
How many wives?
2 wives. Milord, this is the second out of. In Muslim marriage, it is
2 wives, my
two
lord.
wives Muslim marriage, my lord, it is permitted. My lord,
This is the
Muslim
second
marriage,
round
it is
of
permitted.
litigation, my lord. First round of
Let me
litigation.
submit.
Acha.
My lord, subsequently, my lord, first wife, my lord, fraudulently obtained the fair price shop document. My lord, subsequent, first wife fraudulently obtained fair price shop dealership. Thereafter, my lord, the same day complaint has been made and representations have been made
By you.
by me.
You are the second wife.
I am the second wife. I am having a daughter. First wife is having one daughter and one son. That's it. My lord, subsequently, same day representation have been made before the controller, subdivisional controller, my lord, and complaint have been made. My lord, the respondent authority sat tight over the matter. My lord, thereafter I filed a writ petition before this honorable court. Justice Raja Basu Chaudhary disposed of the writ petition by directing kindly comes to page.
Yes.
My lord, 17.
To consider.
To consider the representation.
Then what happened?
My lord,
Kindly come 18.
by submitting
Page
a
number 18.
Nikanama. My lord, since at that point of time I was not having the Nikanama. My lord, thereafter, at the time of hearing, I submitted the photocopy of the Nikanama before the
Where's the original?
original is with me. My lord.
Original is with you.
Yes.
Now what happened?
My lord, my case has been rejected solely on the ground that photocopy has been submitted.
Not the original.
Yes.
Sir, you consider the original and take a fresh.
My lord,
My lord, without it
That
granting.
ground, only on the ground that photocopy has.
Yes, kindly
My lord,
see the
kindly-
reason order page.
my lord, kindly come to page number 18.
Yes.
Paragraph number 6, paragraph 6, my lord. My lord, my lord, having heard the learned advocates appearing for the respective parties and considering the materials on record, I find that petitioner has failed to establish that the petitioner is legally married second wife of Majidul Haq, the husband. No document has been disclosed. Having regard thereto, the respondent could not have been faulted to have been decided on the petitioner's application, my lord. The subsequent, my lord, liberty has been given, though, my lord. My lord, the come to the rejection order, page number 21, annexure P8. Law observation portion, my lord, last paragraph.
Yes, we have photocopy without production
Sole
of the
ground.
original.
Yes,
Sole
your lord.
ground.
So now here's the original. We consider that upon considering the original.
My lord, no verification was made. My lord,
What is
no
the-
inquiry was made.
That was the ground. Now he has the original.
Your lordship, but the instruction yet not received by us, my lord.
This is the ground.
My lord, one more submission, my lord. My
What
lord,
more submission?
page 12, my lord.
I cannot find, yes, it is like that.
My lord, kindly record my submission that the panchayat of the concerned Gram Panchayat has issued a legal heir certificate wherein my name allowing the daughter.
Where is the authority, Mr. Das? Under the Panchayat Act, issue a legal heir certificate by the Panchayat. Please show me. Please show me, under the Panchayat Act, the Panchayat authorities have the power to issue legal heir certificate.
My lord, Pradhan has issued. My lord. Pradhan has issued.
Please show me the authority.
Kindly,
I asked you to stop, you wanted to.
well, kindly, one line maybe adding the
More submissions you will make will be in difficulty.
veracity of the document, the genuineness of.
Yes, after they produce, we will consider everything.
But
by the veracity, genuinity,
Yes, your lord.
everything.
Yes, your lord.
The order dated 1st of July 2026, passed by the subdivisional controller in bracket food and supplies subdivision is under challenge in this petition. First paragraph, Mr. Das Learned Advocate appearing for the petitioner submits that pursuant to an order passed by a coordinate bench on 26th of April 2026 in WPA 2470 of 2025, the petitioner appeared at the hearing conducted by the subdivisional controller, and produced the photocopy of the marriage registration certificate.
The private respondent, my lord, the has not been added in the petition, my lord.
You have not added?
No, lordship.
Lord, I have come against the order passed by the subdivisional officer.
Maybe. Thus you have to add them as parties because coordinate bench directed hearing upon all. other legal heirs also. What? No.
But they should be party, they will be agreed, my lord.
Milord, at the time of hearing, Milord, let's
Please kindly come to paragraph 8, page 19. Giving opportunity of hearing to the petitioner and Momtaj Bibi and on the who's Momtaj Bibi, first five.
Yes, your lordship.
So,
Milord, at the time of hearing.
no.
Milord, allow me to come back next week, Milord.
What next week?
Next week I shall have a private response and come back.
So when this order was passed, the other heirs appeared.
But they did not appear, my lord.
Then
My lord, the appear, I don't know, my lord, is absent. No, there's no,
They choose not to appear.
I don't know, my lord, what I have not, I did not receive the first petition. My lord.
the order does not record that. I will give you liberty, call them, everyone, after hearing them.
Well, may I, my lord, let them added the party and the copy be served. In the meantime, we will take the instruction as well.
When this
Milord,
matter is
allow me to
taken
come
up
back
for,
next week.
when this matter is taken up for hearing, the honored advocate appealing from the state submits that the other legal heirs of the husband of the deceased husband of the petitioner has not been included as party respondents. Mr. Test is a submission, Mr. Das honored advocate appealing from the petitioner is for leave to add the left out heirs of the of the deceased husband of the petitioner as party respondent to the petition. Sir, such care is allowed. Sir, the honored advocate on record of the petitioner is permitted to amend the cost article of the petition by adding the left out heirs. Petitioner is directed to serve a copy of the petition upon the added respondents and file an affidavit of service in the next day. This
30th July.
29th of July 2026. And yes, for the fixed matters.
Item number 150.
Yes. SIR. Yes, disposed of. Next.
160.
Disposed of. Next.
22.
170.
Disposed of. Next.
180.
Disposed of. Next.
Item number 30 to 34 is
This late. Yes. Next.
119.
Disposed of. Next.
120.
Disposed of.
121.
Disposed of.
122.
Disposed of.
123.
Disposed of.
123.
Disposed of.
124.
Disposed of.
125.
Disposed of.
126.
Disposed of.
127.
Disposed of.
128.
Disposed of.
129.
Disposed of.
130.
Disposed of.
131.
Disposed of. There is a resolution. Many advocates of principal mentioned that. It's functional. Principal bench is functional. I was thinking that it's not. I cannot actually like to go. You can take a plea that I am starting
But item 76 in your lordship list,
76.
it is covered by your lordship's order. For another financial year.
Yes.
My learned friend Mr. Singhania is here, but he has requested me that he also has another matter. Unless and until that is upgraded, he will not cooperate with me.
76, what do you want?
Let's see, my item number 92.
Well, my item is.
You are appearing in that matter.
No. I'm not appearing.
On that matter, you see, respondent is not required at all. Only 5 minutes.
Look after the interest of my friend.
Who is opposing you in that? You are the petitioner there.
92, yes, sir. Yes, sir.
Who is the respondent?
That's not required. Jalpaiguri municipality, we need to only corrected certified birth certificate. No, that's, I place my case, your lordship, not at all required. Though service done.
Lordship may kindly take up my
Yes, for Jalpaiguri.
Lordship is an earlier Pritam Das in panel. Now subsequently,
This inquiry who is appearing.
lordship, I will intimate him, your lordship.
Please bring in 76, same interim order can be passed.
Lordship, in this
My lord, am I
order
audible?
was passed by your lordship and subsequently in 2 financial year, Justice Gorang.
My lord, am I audible?
The order, same order.
Page 1.
My lord, am I audible?
Only this lordship technically the copy not sub in the DSGI office. So
My lord,
I
am I
am
audible?
without brief, without instruction.
We have some copies in the office of the assessing officer.
Yes,
I
department.
was not aware, my lord.
Department.
Next time I will instruct my advocate on record.
But what is the system here?
Lordship, in addition, Deputy Solicitor General Office, that is our office, receive all the briefs of the central.
I think the central government advocate or something.
Yes.
CID judiciary.
My lord, am I audible?
Yes.
Judicial, there it is mixed up. Here, what is the practice?
Yes.
Here, your lordship, one copy is served to the DSGI office and a direct income tax assessing officer.
That he has done.
Yes. Then
In addition, to the
DSGI office. Then we communicate with the department or department communicate with us. That's
Do you have an extra copy?
Yes.
Or you will send the soft copy also.
Soft copy we have got, but I think my learned friend will require.
Given a soft copy will do, or you want
No,
a hard copy?
let us say soft copy sufficient. Prior 2 or 3 days with the soft copy, I'll intimate to the department already send and take the instruction.
तो এটা हम কথা
Yes,
এটা हम কথা
which page?
না
এটা আমরা কাছে না
But that was for the financial year 22-23. This is 23-24.
আছেন অনলাইনে দেখতে আছে লর্ডশিপ লানে ডিএসজি অন ভার্চুয়াল মোড অ্যাপিয়ারিং
Yes. 521. Yes.
Now, only one alteration, now that your lordship will find in that case, a show cause notice was also issued under 271 capital C. In this case, it is not yet issued. Same, I did.
Further notice under section 271.
That is not there, that is not
Of the income tax
That is
act,
not
such and such was also issued.
That is not.
So that is not here in this.
Yes.
And
Otherwise,
this is for financial year.
this is 23-24.
This is for financial year
23-24.
2023-24. What was the interim order?
And the interim order was like this. Now, kind of take, yes.
Proceed with the.
It is made clear
kindly take 524.
Proceedings shall continue, but no
Yes, Lordship.
no final orders.
Shall be passed without leave of the court.
Leave of the court.
This matter is still pending.
Yes, Lordship, we have already filed the affidavit.
Actually, these
Affidavit
there
excess
are
complete.
5 years involved. Other- If they file affidavit
No,
in the
no,
meantime,
postponed.
other all these matters can be disposed of at one go.
Not in this circuit.
Not
Lordship, in the first matter, if your Lordship take the, for hearing your Lordship, Income Tax Department will ready your Lordship.
এই affidavit দিস না।
দিয়ে দিয়েছে নাকি
না,
তোমাকে?
না, না, না।
পরের চারটাতে দেওয়া হয়নি।
এটা দেওয়া হয়নি পাইনি আমরা সিরিয়াসলি
Now, can't pass an order for another financial year.
three financial year
একটাতে
Well, I
আমি-
stand corrected.
We have
Madam,
annexed
Mr.
to one.
Singani is correct in first matter, which
I will-
Lordship,
Yes,
Mr. Singani has, I mean, department has filed it.
yes, I've already filed.
Where I passed the interim order.
Lordship,
We will file.
That was the first matter.
first matter.
In fact, one matter, if it is decided, it will cover all
Yes.
the
Yes, in the
So,
first matter.
That was with regard to 22, 23.
23, 23.
And Justice Kant passed an order in the
Mother, in
Subsequent
respect of
period.
2019, 2020, 2021, 2022.
Yes,
The Lordship will find that order of Justice Kant's order. One order we have annexed, that is at page 525. Just after the annexure, P20.
interim order was in similar lines.
Absolutely similar. Line.
only some changes, your Lordship, in this connection, there was a mentioning for income, Supreme Court's SLP, your Lordship. Judgment of the Madras High Court, your Lordship, where income tax authority win this case.
Yes.
Against which the SLP was preferred, which is pending.
That is regarding 127. And the Lordship will finally take Justice Kant's order.
Yes.
If your Lordship can take that, yes. It is that? 5 to 5, kindly take. Yes, now accordingly, the respondents are permitted to proceed, para 14. Para 14, yes, proceed with the adjudication. No final order shall be passed without the prior leave of the court.
If such leave is granted and the final order, the same shall be
Given in
in
abeyance
abeyance.
and shall not be given in effect to in terms of the order of the Honorable Supreme Court and shall abide by the outcome of the special leave.
In effect, so that cannot be given effect.
As you can see. Same. Identical manner.
Lordship, in next 4 matters, one matter already we have dropped the on because limitation period. Next 4 matter, in one matter, your Lordship, for the save the limitation within 31st March, we have preferred and can application for grant liberty to publish the award. Proceeding is complete.
Because otherwise it will be time bar.
Time bar, your Lordship. So file the can application.
This
Yes,
period has to be,
pendency, there is a,
period has to be excluded.
that is to be excluded, but that is why I think Justice Kant has
Yes.
passed that,
Yes.
even that rider. he
For this
passed-
year, my lord, for 23-24, my lord, the period would end, because section 201 subsection 3 provides that it has to be within 7 years from the end of the financial year in question. Financial year in question in this case is 23-24. So 31st March 24. It takes us to 31st March 31. So enough, sufficient time in this case, sufficient time. In that case, Mr. Singhani is correct, because otherwise they made an application, that's a protective act.
Yes.
Other facts,
Identical. And I can produce the orders and.
Lot.
then I'm following with those minor changes.
SLPC 401. We include that order at page 401.
401.
Improved order is at page 401. But it also will get a clear picture from 401 itself. Malad, we can take 401.
Yes, 401.
Kindly take, my lord, in response to show cause notice your lordship has got, paragraph 4. The first bullet after paragraph 4 at 401.
1.
First bullet after paragraph 4, after my lord in response, is hereby disposed of as discussed here under. My lord, you got that?
I think
Pagination is
401.
401.
Yes, 401.
Kindly take, my lord, the first bullet.
First bullet.
Your lordship will find references being made to FY 22-23 with respect to which your lordship has passed the order.
Yes.
So, my lord, it is same, identical. Yes, identical.
Page 521. This is 23-24.
23-24.
There is no show-cause notice.
So, show-cause notice is there, my lord.
No, sorry. There is no 171C.
271C is not here.
271C, there is.
There is none. There is none. In this case, there are two issues.
Same, model. 584. Mr. Bojumdar, shall I make that clarification?
Well, in this case, it may not be necessary because 7 years they have got.
7 years.
Yes.
So Mujumdar is appearing.
Yes.
So Mujumdar to question. Yes.
But I kept my word, Mr. Singhania.
Lordship thinks that.
Mr. Mujumdar, whether it's
But I have to travel to Hyderabad. Tomorrow I have a matter in Hyderabad.
from here,
From
or you can to Kolkata.
No, there is a direct flight to Hyderabad.
From here.
Yes, my lord. It's a 6 o'clock flight.
Lordship, my
You are
matter.
not in a hurry today. Some other matters.
Lordship, in item number 92, kindly think that talk tomorrow, your lordship, I'll bring with Mr.
See who is appearing.
Lordship, Pritam, your lordship.
I will be taking up to date itself if you can bring the other side.
Lordship, see if I
Yes.
try. Otherwise,
Yes,
your lordship, tomorrow kindly top your lordship.
Yes.
I'll manage.
Yes,
Lordship.
all the list.
Item number 92, your lordship.
Kind indulgence and permission of your lordship, can I mention?
Yes.
A writ application was filed by the petitioner, number 997 of 2025, being arbitrarily terminated by the answering respondents. On motion, that is on 1st of 1/8/2025, on Honorable Justice Amrita Sinha had passed, looking into the urgency of the thing, and with consultation with the answering respondent, had fixed the date of 2 weeks to file the affidavit in opposition. But they failed to do so. Later on, it was again mentioned on 1/8/2025, and his lordship, Saugata Bhattacharya, had passed a preemptory order directing the answering respondent to file it within 2 weeks. They have failed that also. Subsequently, finding no other alternative, I had filed one can. That was disposed of with a direction to file as mandatorily 2 weeks. But they have not filed and the matter is not coming in the list. Honor, your lordship, the petitioner is out of employment for more than 1,500 days. And from their own document, I can on the threshold project that the termination was totally arbitrary and their document doesn't support their allegation. My humble submission, the matter is to be listed.
This, if this week comes, please can come in the next week, I will come.
Can I find the mentioning,
Not in this week, come in the next week.
Monday coming from Siliguri is the problem, then can I?
Yes, the law is there. Yes.
I'm also applying.
Yes, call the next matter.
Item number 1.
Item number one, it has been pointed out that in the order dated 21st of July 2026, the item number of the daily list of that day has been wrongly recorded as 24 instead of 30. It's such a right? Sorry. 21st of July 2026, other portions of the order shall remain other. Next, item number 22.
What is the matter of the 3% increment order? There is a 3% increment order.
Same as 20, my lord. Same as 20.
Same as
20, Lordship, because in this case, the 20 is not.
No representation.
Same as item 20.
Only, my lord, date will be changed, my lord, the joining and upgradation.
Yes.
Joining, my lord.
Joining and upgradation. Joining as headmaster, what is the date?
24th July 2019.
24th of July 2019 and upgradation?
10 June 2010.
10th June 2010.
22nd June 2010.
Let's call the next matter.
22nd June.
I don't know 23.
23 also same.
23 same.
23 also same. Join on 18 July 2019.
Joining date 18 July 2019 and upgradation?
Upgradation 26 June 2009.
26 June 2009. 2009.
2009.
Yes, for the next matter.
24 also
24
same.
same.
Same 19 July 2019 joining date.
19 July 2019 joining date.
Upgradation will be 18 July 1995. That was the upgraded school.
In July 1995.
95.
Next. 25.
Next also same. Joining date 18 July 18 July 2019.
18 July 2019 joining date.
Upgradation 26 June 2009.
26 June 2009. Next. 26.
26.
Same.
This is the similar matter. 17 July 2019.
My lord, is matter is Mila and
Joining date.
17 July
Joining
2019.
date.
17 July 2019.
17 July 2019 and upgradation.
Upgradation 5th September 2005.
5th September 2005. 5th September 2005.
PI of school sent us a notice, a letter stating that the GO, earlier GO that has been withdrawn.
Yes, yes. That yes. Yes, for the next matter. 26, 27.
Lagmena.
What is this matter?
Police in action. In respect of the private respondents, the service is not complete. We have served the state.
In respect of the private respondent, service is not complete.
Madam, we have served the state.
Police in action, what police in action?
Actually, madam, for the case is concerned, in subsequent application, earlier application, madam, we have filed a complaint at the Kotwali place.
Learned advocate appealing for the petitioner submits that the service of the petition, that the copy of the petition has not yet been served upon the private respondents. The petitioner is directed to serve a copy of this petition upon the private respondents and file an agreement of service on the next day to submit this matter before the next available circuit.
No, next week, madam.
Next week.
Next week.
This matter 30th. Next.
I'm appealing for the petitioner.
Yes.
Very short matter. 28.
Same as 20.
28. My lord, this is 28.
28.
Yes.
Joining date.
28.
My lord, 28 is PCM cement concrete.
28.
PCM cement concrete.
No. 28, my lord, the 3% additional increment.
I beg my pardon. I beg your lordship's pardon. I beg your lordship's pardon.
Yes, yes.
This is same as
What is the date of joining?
joining 24th July 2019.
24th of July 2019, joining date and upgradation?
Upgradation, my lord, the 12th August 2011. 12th August 2011.
12th August
11.
2011. 11, yes.
I get to
My lord, I'm appearing for the petitioner.
My lordship, in item
My lord,
number
I
29,
appear for the petitioner. This is a very short matter. What has happened here, lordship?
my lordship,
my lord-
small indulgence, my lordship. In item number 20.
Yes, call the next matter. 29.
29, I'm
Yes,
appearing
who
for
is
the
appearing?
petitioner. I'm appearing for the petitioner. I'm appearing for the petitioner. My lord,
Yes,
what has
Mr. Bajaj.
happened here? My lord, I only pray here for
Call
a
the respondent.
re-adjudication. My learned friend is appearing through VC. Mr. Agarwal is there. Yes.
All right.
So, my
Yes.
lord, only a small prayer of re-adjudication. Why I'm asking or praying for re-adjudication? That is because lordship kindly comes to page 96 first. The impugned order starts from page 86. Lordship kindly comes to page 96. There
My
are
lordship,
two
item number
two
29,
grounds.
I'm appearing for the respondent, but
Two
the date
grounds.
of viewers of today morning itself, and the date of the hearing was put on 24th, my lordship.
What?
24.
It was supposed to be appear in the list on 24th, my lordship.
Affidavit of service. My lord, affidavit of service is there with my learned junior. If lordship kindly takes it up, affidavit of service.
Yes, yes. Where is the notice?
My lordship, the date of
in that itself,
appearance
in
is
that
24th
affidavit
on
itself.
the letter, my lordship.
Letter? How can it be 24th?
Yes, yes, Mr. Bhattacharya, you have mentioned the date of 24th in the service letter.
Then, my lord, it has to. If they
Yeah.
take this point, then it has to wait.
Evidence of service.
My lordship,
filing
may
for
kindly
today
fix
is
on
taken
Monday, my
date.
lordship.
Not on Monday, my lord. It can be. It's a very short matter. It can be taken up to tomorrow.
The learned advocate appealing for the.
We have to take instruction, my lordship.
Yes, the authority submits that in the communication letter it has been mentioned that this matter is supposed to appear on 24th. So submit this matter on 24th of July 2026.
Great.
Yes, next. SIR. SIR disposed of. Next. Number 31. Disposed of. SIR. Disposed of. Next. That will be disposed of. Next. 34. Disposed of. Next. 35. Yes. What is this? What draw? Yes, yes, Mr. Kundu. Please give a copy to her. Have you seen the order? What draw? Please give a copy to her. Here also you deposited by 2 treasury challans. Yes, disposed of. Yeah. Yes, next. 36. So husband was the son. Yes. 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 Yes, disposed of. Yes. Died in harness. Died in harness has to be from the date of death. Date following the date of death. Not from the date of retirement. Yes. Area pension from the date of. How can it be date of retirement? Because yes, from the date following the date of death. Correct this. There's a wrong mistake. Please correct this. To go through this, otherwise, I'm also not looking, just came into my mind. Corrected. From the date following the date of death of the husband. From the date following the date. Following your comment. From the date. Yes, sir. Yes, call the next matter. Item number 38. Single PPO. Yes. Any. Yes. I support the executive service. I need to place second in record. State is represented to record for you. Yes. Yes. Right. You got it, na? State in Mangalore, they can even. Call the next item. 39. Yes. Yes. What is this? Device PPO. Yeah. The order. Don't have the order. Yes. Next is the I'm passing it over tomorrow. I'm keeping it. This will start. It has said this is device PPO. It will leave the item. It is suggested the device PPO. Pass over. Next. Single PPO. Only for gratuity. Yes. Next. Next. Only here gratuity and pension. Gratuity and pension. Yes, next. Yes, gratuity and area pension. Yes. Next. Gratuity and area pension. Yes. Next. Next. Overdrawn. You don't have the corrected copy. Overdrawn. Overdrawn. Actually, do you have an overdrawn amount? Item number, what was that item? Those dates will be necessary. What is the amount of overdrawn? Which paragraph you have stated? Which paragraph was overdrawn? 35. Yes. Yes, by 2 challans he has deposited. Total 4. What is the total amount of overdraft? Paragraph 5. Amount of overdraft amount 208,007. And where you have deposited? Which paragraph? Paragraph number 6. Paragraph 6 on 4 dates. Then you will be entitled to interest from what date? The last date. From the last date. From 8th of March. From 8th of March 2022 to interest. Where? Interest from 8th of March 2022. Yes, sir. Yes. Yes. Yes, for the next matter. For single PPO. Gratuity and area pension. Yes. Next. 5. You don't have. Device PPO, you have the honor. All right, tomorrow. Not today. Next. 8 is in the title. Yes. Next. Don't have the order. Device PPO, but they, not today. Then what drill? One date, one challan, 2 dates, 2 challan. Which paragraph? What is the amount of our trial? Paragraph? Paragraph 7. Amount.
Such amount of overall may be adjusted against the amount of driving age that we have.
No, here that amount has not been adjusted. So that is to be, now is to be refunded with interest. If that amount is not paid, it is to be adjusted. So now the other dues have been paid, only this amount is to be adjusted. 272, 280. And all right, not today. Not today, yes, next. 48. 48. Gratuity and area pension. Yes. Disposed of next. 49. Gratuity and area pension. Yes, disposed of next. Died in harness. On the date, following the date of death. Number 51. Yes. Device PPO. Sir, Kundu, can you give her the copy of judgment device PPO so that she can come ready with that? It's a device PPO. Yes, disposed of. Please give her the copy of the order. 52, yes. Yes, disposed of. Gratuity and area pension. Yes, for the next matter. It's a revised PPO. Please give your appearance. Yes. Disposed of next. Device PPO. Yes, disposed of next. Five. Let's speak you. Yes, next, disposed of. Six. What trial? Yes, refund. Not, no, refixation cannot be done. No, here, please, go through this order. It is No, please see the order. Refixation cannot be done. All right. Why are you making prayer for refixation, Mr. Unnecessarily you are creating. What is that? এটা একদম উপরে লিখে দিই Yes, what you said to this refixation, not pressing. The learned advocate appealing for the state raises an objection against the relief claimed by the petitioner by way of refixation of the pension full stop. The learned advocate appealing for the petitioner submits on instructions that the relief claimed in the petition insofar as this refixation of pension is concerned is not pressed by the petitioner. So such submission of the learned advocate for the petitioner is placed on record. Yes, next. Refix. Here also refixation. Overall, Mr. Kundu. Why refixation? Same or operator it has we can go to in the other overall also you have made refixation. Yes, next. 58 also refixation. Only overall. এখানে না শুধু এই ফার্স্ট পার্টটা থাকবে না শুধু এটাই Yes. This is the I heard it's clearly mentioned you use the service record and at the time of processing the petition case, it was detected that the petitioner had received excess salary due to work session. Consequently, the excess wire was assessed to be 294,532. Therefore, the claim of the petitioner is not sustained. Sir, have you considered the decision of Rotic Masi? Cannot do that, cannot claim. It is that. Please consider this. After retirement, you cannot claim on account of. Please go through that. That is the exact issue which was considered in Rafiq Masi. All right. Thank you.
My objection.
Yes, next. Yes, next. 59. Yes, what is this? What rule? Device. Yes. Disposed of. Next. Yes. How many matters you have filed? Died in harness. You have corrected that. Father of the petitioner. All right. Yes. Disposed of. Next. Who is for the state? Yes. Instructions. All right, on the prayer of the learned advocate for the state is to spread in the next year. Yes, next. Sorry, 62. Yes, disposed of. Next.
Lordship, in this matter, we need time to seek instruction.
Yes, on the prayer of the learned advocate for the state is to spread in the next year. Yes, next. 4. What rule?
This matter is also overdrawn matter. My lord, we are expecting our instruction from the concerned.
On the prayer of the learned advocate for the state is to spread in the next year. Next. Yes, 5. Yes. Yes, disposed of. Yes. Next. Yes. Yes. Where is the what rule? Which paragraph? What rule? Paragraph 6 is the amount of overdraft. Paragraph 6. Paragraph 6 is the amount. And when have you deposited? Which paragraph? Nineteenth of March 2025. Yes. Also, next. Yes, next.
I'm here for the state, your lordship. Kindly see the page number 12 and their second prayer. And I have an objection.
Second prayer. What is the second prayer?
Defix the amount of monthly pension of petitioner on the basis of the last pay drawn by the petitioner and
This is overdraft. Defixation cannot be done. Repeat session, ওই যেটা I not press করতে না repeat session, ওইটা করে overdraft. Overdraft, which paragraph? Paragraph number 6. And deposited. Which paragraph? 8/9/2023. Yes. Yes. Full stop. Next. 67. Decision are not stressful. Yes. Overdraw, who is for the state? Madam, you can appear for the state. Who will appear?
If my lord regularize the.
Yes. Paragraph 6. And Treasury challans. 3 challans same day.
My one is they are appearing in.
You are appearing.
Yes.
I will, my part. Yes, next. PH. What is this? What drug? Who's appearing?
I appear in this matter. We need instruction, my lord, in this
Next
matter.
week. Yes, on the pair of the land. Yes, next. Nine. Not today. Yes. Yes, next. 30. Yes. You are appearing. Regular exception to be made. No? Yes. 71 who is appearing? Yes.
Your decision was supposed to be given by the state today.
Yes. So
that was not communicated, my lord. I'm handing over to copy.
Now you have the order. Yes. What is the decision?
Decision, my lord.
Their favor or against them?
No, against them. Not in anybody's favor, my lord. It has said that all the appointments are initially made strictly. I'm placing it, my lord.
What is the issue here?
Issue is that, my lord, the petitioner has alleged that the earlier headmaster of the school
had assured him that he will be given a contractual service there and had allegedly taken some money from. That is the allegation. And he's saying that that has not been fulfilled.
That was not considered his representation.
Yes.
Now the order has been passed.
Yes, one order has been passed.
Lordship, Dr. Arjun Chaudhary will be appearing in this matter, Lordship.
If you are agreed to challenge this order, now he's
Lordship, I just need to communicate this to Dr. Arjun Chaudhary. His father is seriously ill. He's hospital, Lordship.
Your fear was that the order has not been complied with. Now they are giving the order. If you are agreed, I will challenge.
Lordship, kindly keep it on next week, Lordship. Lordship, kindly.
That's your fear.
Lordship, but I have instruction from senior Lordship. Kindly.
Actually, a serious father was suddenly taken to hospital.
Yes, Lordship. Kindly keep it next week, Lordship.
So what is the additional government meter? Files the copy of the decision taken by the school authority, which was communicated to the district inspector of schools, AC Calcutta. So the copy of the order decision dated 10th of April 2026, filed by Mr. Bhattacharya is taken on record. So a copy of such order has been supplied to the learned advocate for the petitioner. Go today to serve the learned advocate again for the petitioner 6 times to take instructions. So this better. Tomorrow.
No, Lordship.
And
Next
keep
week,
it on
Lordship.
Monday.
Grateful, Lordship.
Under second. Yes, name.
My lord, in this matter, I'm appearing for the petitioner, my lord. Please appear virtually.
Yes.
My lord, this matter is regarding a very short point on tender. My lord, this petition is challenging the procedure. My lord, this petition is challenging the procedure by which they have first disqualified the tender applicant and then subsequently my lord, they have undisqualified them. My lord, the private respondent, they were first disqualified in the technical bit. Subsequently, they followed a procedure which is not as per law, and then they said that subsequently they pass an order saying that you are now being qualified. And this is the process I'm challenging in this petition.
What happened to you? You have been qualified.
No, but I am qualified. I'm challenging the order on the fourth
He is also
respondent.
qualified. In the technical bit, he is also qualified.
My lord, I was qualified.
Yes, qualified.
Yes.
Yes, my lord. I was
Yes.
qualified. My lord, my challenge is on the third party, on the private respondent who was first disqualified. Later, he was qualified by following a procedure which is not as per the law or as per the procedures laid down. My lord, that is where the challenge lies. My lord, let me
Yes.
place the case, my lord. My lord, if you, my lord, kindly come
Yes.
to page number 33. Page number 33 of the petition, my lord.
Yes.
My lord, this in the 4.2C3, my lord, at the bottom of the page. My lord, are you there, my lord? Page 33. My lord, am I audible? My lord, your lordship is not audible actually. My lord, your lordship is not audible.
You can hear me.
Yes, my lord. Yes, my lord. Yes, my lord. Now you can.
Yes. Yes.
My lord, in page number 33,
Yes.
my lord, your lordship sees in 4.2C3, there was an eligibility criteria at the bottom, 4.2C3. The second
Yes.
last paragraph from the bottom. My lord, there they said that for a BOQ, a pre-qualification, there has to be duly authenticated by the competent authority. My lord, point number 1, clause 1.
Yes.
My lord, this was the credit. If they have a credential, they has to be certified by the by the authority themselves from whom they have received the certificate. My lord, subsequently, if your
Yes.
lordship comes to page number 32 of this petition, my lord.
Yes.
My lord, at the basis of the page, there is a note saying that no offline documents will be allowed. Subsequently, my lord, page number 32 at the bottom, there is a note, note number 1.
Yes.
No offline documents will be accepted and considered. Your lordship got it?
Yes.
My lord, after that, there was a,
Yes.
we applied for the technical bid, there was a technical bid, TBO. The technical bid opening is in page 63. My lord, in the relevant page is page
Yes.
64. My lord, the relevant page is page 64. My lord, the
Yes.
number three participant. Page 64, number 3 participant. Here's a list of the contractors and the bidders. Here they say that BOQ related to the credential not authenticated by issuing authority, hence disqualified.
Yes.
My lord, as per their NIT, which there is a guideline where they can file an appeal, they can prefer a challenge. I am challenging this qualification, subsequent qualification of this joint enterprise, who is the private respondent. My lord, subsequently what happened? Subsequently, they passed a TBE saying that you have now that this joint enterprise has been qualified. We asked them that how did they were qualified. They said, my lord, subsequently asked for the details. My lord, in the very next page, page number 65.
Yes.
This is where it is being, this is my main primary contention, my lord. On 27th April 2026, they pass an order saying that you have been, this party has now been to joint enterprise, you are now being qualified. Everything is found to be checked and genuine, hence you are declared to be qualified.
Yes.
Well, the date is very relevant over here. The date of this order is on 27th April 2026. Well, at the top, the date is given.
Yes.
Yes, my lord. My lord, for the TBO, the technical bid opening, the date was 11th March 2026. So these 2 days are very important in this matter, my lord. If you can, it may be noted. My lord, subsequently, what happened? We asked them, asking how did he got qualified, under what circumstances, and how did they, a person who was qualified, disqualified on the grounds that their authenticated documents were not submitted, how they got qualified subsequently without us knowing it. The very next page we mailed the department. The department responded by saying that as per the the response is in page 70.
Yes.
If I place this notice, this response to the query we had sent them, as per the direction of the appellant authority, his relevant documents were sent to Executive Engineer Jalpaiguri for verification. The same was found to be genuine as reported by Executive Engineer Jalpaiguri Highway Division, and accordingly, Minister's joint enterprise were declared to be qualified. This is my contention is. How did they accept any manual documents when the NIT, the notice invited tender, categorically said that they cannot accept any offline documents? My point number 1 is that. The point number 2 is that the appellate authority, the appellate proceedings that has been laid in the NIT, which is the rules of their department, is in page number 42. In the 42, it says that there is a time limit. In page 42, there is a process in page 42, 15.4.
Yes.
In 15.4, they have given a time limit specifically that after submission of TBO, they have if anybody has an objection, they can file an objection within 24 hours. Within 2 days, they have to pass an order. If they are aggrieved by it, they have to file an appeal. And subsequently, after 2 days of filing the appeal, they have to pass an appellate order. The entire period has to be done within a period of week from TBO, the technical bid opening date. That in this case, it has been done for after more than 1.5 months. The technical bid opening was on 11th March 2026. The order that was passed But for allowing them by not disqualifying them is on in April 2026. The TBO is in page 63. This was issued on 11th March 2026. And 64, the signing date. And the order they have passed is in 27th April 2026, which is more than 1.5 months. And they have accepted manual documents for verification. And where the categorical in E90 they have said that this cannot be submitted manually.
Yes.
Well, this is my case in this matter. The entire process that was followed in coming to a decision is biased. It is a complete violation of Article 14. And this is my case. Not even subsequently, there is one more point, my lord. They said in page number 13 in general procedure that you cannot submit after a bidding is closed, you cannot submit any additional documents. In page number 30, my lord. 4.1. At the bottom, 4.1, 4.1, my lord. At the bottom of it, at the end of the page 30. Page 3030, my lord, at the bottom. 4.1 is the general procedure.
Yes.
At the last line, the documents digitally signed and uploaded in e-tender portal by the contractors bidders containing requisite information and financial bid rate comprising technical bid and financial bid are submitted concurrently, which cannot be changed after the end date and time fixed for submission of the e-tender. My contention is that if a document which was not verified and it was disqualified because it's not as per tender, how can that same party be qualified by checking it manually?
Yes.
That is my case.
Yes.
That is all the cases. My challenge is on the making this private respondent a qualified candidate after making them disqualified on the ground, which is very technical. It's not, I'm not saying that they cannot verify. They're not verified. They have accepted new documents, which is signed or pre-signed or authenticated by a third party, which they cannot do as per their own NID. The notice inviting tender, the rules that have been framed.
Yes. Anything more?
No, my lord. This is my case actually.
Yes. Your interest will be protected by Mr. Bhattacharya.
Let's see. My lord, if the tender goes through, my lord, the interest of the state gets protected. My lord, I'll trouble your lordship again with point 15.4 at page 42. Where the time
42.
limit, page 42, my lord. The appellate provision, my lord.
Appellate provision.
15.4, my lord.
15.4.
Yes.
Yes.
Now, my lord, the time frame. Now, I'll, my lord, draw your lordship's kind attention to the 7th line, my lord. It starts with if the bidder, my lord has got that.
Yes.
If the bidder is not satisfied with the clarification of the TEC, he may appeal to the Secretary INW Department within 24 hours of receipt of communication from the TEC. The Secretary INW Department will dispose of such complaints jointly in associated with at least one available chief engineer, such and such within the next working days. And subsequently, now, my lord, the question of the time frame, it says may appeal. It does not say shall appeal.
No, it says may appeal.
May appeal.
Yes.
So, He can.
Here he has preferred an appeal, yes.
Preferred an appeal. Now, after the appeal, what has happened, my lord? The secretary, my lord, went through the documents and found out that one of the document was not authenticated. Before I, my lord, respond to that, I'll draw your lordship's kind attention to page 32 of the writ petition, my lord.
Yes.
My lord, there is a table there and below the table, my lord, there is note 1. My lord, is there?
Note 1, yes.
Yes, I'm placing it. It is desirable but not mandatory that all documents stated above in PDF files shall be uploaded by bidders only in specified designated folders. No offline document will be accepted and considered during tender evaluation stage from bidders before publishing result of final selection of L1 by publication of FB sheet. Verification and authentication of bid documents during bid evaluation by TEC, while the memorandum number dated is given, and its corrigendum order number such and such may be undertaken from bidders or directly from PQ credential issuing authority. So this gives, my lord, that much space to the evaluation committee or the appellate authority to call for a credential document from the credential issuing authority. Now, in this case, what has happened, my lord, was that the private respondent, the documents which he had initially, my lord, uploaded, I'll say that after it was received, my lord, we had forwarded a letter to the executive engineer, Jalpaiguri Highway Division, asking for authentication of one particular document, my lord.
Who has given a letter?
The superintendent engineer, the appellate authority.
Where is that?
That is here, my lord.
Yes.
I just have one copy. I'll let it over.
All right, then.
My lord, here it says that with reference to the above noted subject, Messrs. Joy Enterprises submitted BOQ, completion certificate and statement showing the actual quantity executed to support the credential during submission of online bid, which were issued from your end. So you are requested to verify the authenticity of the said document at the earliest. In response,
so this was done after Mr. Ghosh's client preferred an appeal.
Yes, the appeal, my lord. This is for the verification because one document was not there, and their verification was not there. So it said that thereafter, my lord, the verification reply comes. The executive engineer writes to the chief engineer, Northeast Irrigation and Waterways Department, says that the undersigned is the executive engineer, is hereby ensured that that refer completion certificate quantity statement were issued from this end in terms of work order, video memo number such and such of superintendent engineer. That, my lord, is the clarification. Based on this clarification, my lord,
yes,
the authentication was verified, and thereafter, my lord, the private respondent, Joy Enterprises, was cleared, man.
Yes.
This is it, my lord. So there is no information in my humble submission.
No, and another thing is the time frame which he was which you are saying,
my lord,
that this appeal order was passed after more than 1.5 months. Is there any time limit for that?
My lord, it took some time because it had to be verified from the end. It had to be verified from the end of the authority whose documents was uploaded by them. Since initially all computer generated documents were uploaded, there, my lord, the verified document was not there. And that is why, my lord, the appellate authority had to ask for a clarification regarding the authenticity. And that authenticity was provided. That took some time. But there is no infirmity in my humble submission or irregularity in that process. And as of now, my lord, the tender stage, it is still in the stage of, my lord, consideration. No final decision has been taken as of now.
It is at what stage? Technical bid?
Is it?
Financial bit has been opened.
Yet to open. Financial bit is yet to be opened.
Yes. Anything more?
No.
Milord, once the tender was submitted to support of my credentials, the documents were attached in the online portal. One credential on which I relied upon was a system downloaded document without any signature of the authority. I was initially, my application was rejected on that account that one of my credential certificate is invalid due to non-bearing of the signature. I preferred the first appeal before the tender evaluation committee, rejected. They said that no, it is an invalid document. On the next day, on 17th, the next day I preferred the appeal before the secretary. On 17th. Second appeal before the secretary. If in respect of
Where
which,
is that provision? With
Milord,
regard to two appeals?
15.4.
At page 42, my lord.
No, 15.4 is the second appeal.
No,
First appeal,
first
second
and
appeal, both.
I had, my lord, drawn your kind attention to the second appeal.
All right.
My lord, the
This
15 point
15
says for a clarification,
Yes.
then an appeal, my lord. There is no second appeal.
Milord,
They can ask for a clarification.
first Milord,
Please give me a minute. Yes.
within 24 hours of uploading the TBO summary, sheet containing preliminary technical qualification result, any of the aggrieved bidder may seek clarification, redress, review from the TEC, that is the Tender Evaluation Committee, on the list of bidders in writing through email, so and so, so and so, so and so. The next sentence, in case the review only seeks the eligibility of the applicant himself, views of the Tender Evaluation Committee would be communicated in writing to that bidder within the next 2 working days. This is Milord the first stage. It's over now. Next line, if the bidder is not satisfied with the clarification of TEC, she may appeal to the Secretary, Irrigation and Waterways Department within 24 hours of receipt of the communication from the TEC. Now, Milord, my first clarification which I sought, that is on 13th of March 2026.
Where do I get that?
Milord, it's my document, Milord. I will place this. Milord, I'll just give your lordship the dates. Clarification was received on 16th, affirming the decision of rejection. On 17th, I preferred the appeal. That is on the next day. 13th, I preferred the clarification.
13th of
March 2026.
Sought for clarification.
Sought for clarification, I clarified that this is a system generated document, hence does not bear a signature. You may verify it at your discretion. They respond me back on 16th of March. Saying that, upholding the decision basically of rejection. 16th of March.
Rejecting the prayer.
Rejecting the prayer. 17th of March, I prefer the appeal, the next day. Before the secretary, who is the appellate authority. On 19th, that is within 48 hours, 2 days, on 19th, I receive a communication from the secretary fixing 25th March for a date of personal hearing. 19th, the secretary response fixes 25th of March 2026.
Yes.
And thereafter, Milord, they take the decision that I am qualified. That was, Milord, on 27th of April.
So in the meantime, they have sent for those verifications.
Those verifications. These are, Milord, my documents. Now, Milord, on the point of law, admittedly, Milord, apparently on the face of it, this 2 days time period has been breached. Now, Milord, subsequent to Michigan Rubber, all the judgments, Milord kindly recalls, the position of law is infractions of a contract with regard to tender will only be material and requiring your lordship's interference when the infractions goes to the root of the contract. Now, these timelines, Milord, procedural aspect does not go to the root of the contract. Therefore, Milord, there is no cause of action made out for your lordship's interference.
Yes.
That's all, Milord.
My lord, may I please?
Yes.
My lord, there are 2 grounds. My lord, one, my lord, your lordship attention to come, my lord, page number 64 again, my lord, once. My lord, the reason why they have rejected them. My lord, it's not that unverified, it's unauthenticated, which is a mandatory paper. My lord, as I've shown it, Lordship, that this is a mandate as per the NIT to upload it. My lord, they failed to upload something which is a mandatory. Subsequent to verification, the department can check whether what they have uploaded is genuine or not. They cannot change which is mandatory as per law and they have not complied with and change it with something that has been complied with. My lord, in page number 33 again, it was a mandate to file a BOQ or any references or credential which is authenticated. This is a mandatory provision. It's not only binding on the private respondent, on the department, also for us. My lord, in page number 33, it's a mandate. My lord, when a party has failed to comply with a mandatory provision, through revision or verification, it cannot be changed with something which is not there in the portal to something which is there in the portal. It's not they're verifying it, they're changing the nature of the documents completely. Something which is unauthenticated becomes authenticated without being uploaded to the portal, without a manual submission, anything. As per their submission, they have done it within a specific time. But they have changed the complete nature of the entire document itself.
Madam, can I listen?
This actually goes to the very root of this entire tender application process. Because it has to be fair and square. If suppose again another party fails on something that is mandatory, they cannot rectify it through appeal. And that is why what humble prayer is. Something which was mandate. Page 33 was the eligibility criteria for credentials.
Yes.
My lord, again, the second point, my lord, in page number 65. My lord, the memo of appeal date is on 30th March. It's as the other senior friend has said, it is they have applied in 17th March, but memo of appeal in APAT 08 has been referred to as 30th March, my lord, in page 65. It is their department's order where they have referred memo number appeal APAP 0508 dated 30 March 2026 of the secretary. At page 65. In the appeal order, the memo number, they have mentioned it.
No, that memo number, the difficulty is that you are in online. These documents he has submitted, Mr. Ghosh has submitted. This is appeal has been preferred long back. This 30th of March is a memo issued by the appellate authority to the tender evaluation authority to get it certified. That bears the date of 30th of March.
Even for
it's
that
not
also,
that the appeal is of 30th of March.
My lord, accept on that basis also, my lord, how can
that is the
something
difficulty?
nature of
You are appearing online. You cannot go through this.
My lord, may I get
That
a
is the
copy of it?
difficulty.
I'll come back. My lord, may I get a copy of the document that Mr. Ghosh has submitted? My lord, on this also, my lord, even the BOQ has to be authenticated. That was a mandatory. They have changed the nature of the document. My lord, that cannot be done through verification. My lord, that is my humble prayer. My lord, because page 33 it says that it's an eligibility criteria. My lord, that the nature of the
Yes,
document was they have been disqualified. That
when can you come back? After you want to appear physically?
Well, I'll try my level best to appear physically, my lord. Next Wednesday, my lord, it can be kept. My lord, next Wednesday, try and come physically.
Next Wednesday.
My lord,
why Wednesday? Monday, come on Monday. Because there is nothing in it. If you want only for that, your junior is present here. I can give a copy to her.
Well, I will give a copy. No
heard the learned advocate for the petitioner, comma, Mr. Ghosh, learned advocate for the private respondent, and the learned additional competent pleader, full stop. Mr. Mr. Ghosh and Mr. Bhattacharya are requested to supply copies of the documents which they have produced in court today in support of their respective contentions to the learned advocate for the petitioner in course of this day. First of all, the reply argument of the learned advocate for the petitioner, list this matter on Monday. All right. Mr. Ghosh, you have a copy. So I'm giving this. Please file it in course of this day. Yes, call the next matter. Yes. Yes, call.
For the respondents, my lord.
Yes.
I'm appearing virtually, my lord. Very permitted to make a submission of the dispute between the party, the SI department, and the, my lord, the petitioner. Is with regard to, my lord, the employer share, areas of employer share. The present day dues are already clear.
You are not visible, sir. Where are you? You are not visible.
My lord, it is, the video is not working with the court, my lord. Bench is also not visible, my lord.
Yes.
May I make my submission, or should I come back on separate dates? Because the bench is also not visible, the video is not working.
Then it's difficult. Not today, next. Yes.
74, I'm appearing.
74. Yes.
This is a GST matter. It was last day before yesterday where I prayed for a leave to file an appeal. I got the order late. It was uploaded in additional notices and portal. And all limited prayer is give me a chance to file an appeal.
Yes, you want to file an appeal?
Yes, my lord.
Yes, Mr. Mishra, what do you say?
Again, similar case, my lord, additional tab.
Yes, so he wants to prepare an appeal here. So, within how much time you can prepare an appeal?
2 weeks.
2 weeks, then don't dismiss it on the ground of limitation.
That's all my query.
In fact, the liability is too small here, only 52,000 rupees.
Even then, he has a right to prefer an appeal.
And it is costlier than the court fees for filing the writ petition.
What is the order of adjudication dated 22nd of April 2024?
Yes.
And when you came to know?
In May 2026.
May 2026?
Yes, my lord. I have
Thereafter, you have
uploaded the
filed this writ petition.
Yes, my lord.
Thereafter, you all right.
Yes, my lord.
The
Page 33 is the order.
The order of the page 33.
Yes, my lord.
The order of the Assistant Commissioner of Revenue within bracket SGST, Shiliguri Charge Shiliguri, dated 24th of April 2024, passed under section 73 within bracket 9 of the WBGST. Yes.
22nd of April, my lord, the order date.
Yes, 22nd of April.
Yes.
22nd of April 2024, passed under section 73 within bracket 9 of the WBGST Act 2017, is under challenge in this writ petition. Full stop. The learned advocate appearing for the petitioner submits that the said order was uploaded in the additional notice and orders tab and not in the normal tab. Full stop. he further submits that the petitioner came to know of the order of adjudication for the first time only on which paragraph you have stated?
In February 2000.
Which paragraph?
No, paragraph 10.
Only in the month of paragraph 10.
Yes, my lord. He hasn't given a date, but he's talking about the merger of the two tabs.
Only in the month of May 2026.
February.
Only in the month of February 2026, and immediately thereafter, the instant writ petition has been filed. First up, the learned advocate appearing for the petitioner further submits, on instructions, that the petitioner is ready and willing to avail of the appellate remedy if some time is allowed by this court to approach the appellate authority. First up, such submission is not opposed.
No, it is opposed. I say that on a joint reading of 169 with 161, it is a deemed service.
Mr. Misro Learned Advocate, Mr. Misro Learned Assistant Additional Advocate General submits that the order was uploaded in the web portal of the GST authorities, and the petitioner cannot take the plea of ignorance merely because the same was uploaded in the additional tab. First up, it is now judicially settled that uploading of notices and orders in the additional tab cannot be said to be sufficient communication under Section 73 of the WBGST/CGST Act 2017. First up, for such reason, this court is inclined. Now, it is not in dispute that the order of adjudication was initially uploaded in the additional tab and not in the normal tab, and the merger was on, and the
February 2026.
And the two separate tabs were subsequently merged only on 6th of February 2026. For such reason, this court is inclined to afford an opportunity to the petitioner to approach the appellate authority. First up, if the appeal is preferred by the petitioner before the appellate authority within 14 working days after receipt of a server copy of this order, the appellate authority shall consider the said appeal on merits without dismissing the same on the ground of limitation. First of it is, however, made clear that this court has not entered into the merits of the claim made by the petitioner. This court has not entered into the challenge thrown by the petitioner to the order of adjudication, and all points at this stage, and all points are left open to be decided by the authority if such authority is approached by the petitioner in accordance approached by the petitioner pursuant to this order. Yes, disposed of. Next.
May I just
same order?
May I just point out item 9 no, my lord, the order is different, my lord. This in matter, my lord, there was no personal hearing given. They referred to a scrutiny of return, my lord, as I mentioned in Rule 99. They did not issue me SMT 10 also. No personal hearing given. They referred to a scrutiny of returns. My lord, if I may place, page number 26 is the so-called notice, the DRC 01. Yeah, there is no personal
here
hearing.
the date of personal hearing?
NA. And additional tab was also there.
My lord, even for one more case, my lord, in this matter, my lord, in page number 30, my lord, and we come to page
Mr.
number
Miso,
30.
what is being done? Why are you doing this?
No. This problem will not be there after February. It was because the
Why it
merger-
was there prior to February?
It was there because the portal.
No, why any?
That has to be specifically entered by the officer, my lord. That hasn't been done.
Really on
I
this
know.
ground, another round of litigation.
Well, at page number 30. And the order. In the order, they have said that they have 30, my lord. It's the order.
Yes, when the order was passed.
Well, the order was passed.
Order was passed on
9th of April 2024.
9th of April.
9th of April 2024. And where is the show cause notice? Please show me that. What was
Show cause notice is
page
page 25. 25.
Reply was on 8th of January. 8th of January 2024. Order was passed on 9th of April.
9th of April.
Yes, ma'am.
Did you file your replies?
No, my lord. I did
Did
not
you
know.
submit?
It was there. No, my lord. Everything was
When you came to know of this?
My lord,
When
after
you
they have
came to
started
know of
recovery.
this?
My lord, after they have started recovery, my lord. They have issued me a
When?
recovery notice.
What is the date?
Let I'll come to this.
Again, 6th of February 2026.
No, that
No,
is
madam.
the
No,
Merging of the
where is the when they have started recovery? Where have you stated?
my lord, in paragraph number 2.
Paragraph number 2.
Yes, madam. The petitioner humbly states in DRC 13.
5th of March 2026.
Yes, madam.
5th of March 2026.
5th of March 2026.
Yes, madam.
Acha. Ashun.
My lord, there is one more issue in this matter. My lord, in the order, they have said that there is a scrutiny of returns under section 61. Scrutiny of returns referred to a ASMT 10, my lord. That was never issued. That is a compulsory part of that. My lord, last day I had submitted a judgment of coordinator.
That you challenge, you take that point in the reply. That will I will not go into that at this point.
Yes.
The
It can be sent back to adjudication.
the ex parte adjudication order dated 9th of April 2024 passed by the Assistant Commissioner of State Tax SG charge, Siliguri charge, Assistant Commissioner of Revenue, Assistant Commissioner of State Tax, Siliguri charge, Siliguri, passed under section 73 within bracket 9 of the WBGST/CGST Act 2017 is under challenge. Full stop. The grievance of the petitioner is that the pre-show cause notice, show cause notice, as well as the ex parte adjudication order were all uploaded in the additional notices and orders tab. Full stop. The petitioner states that upon receipt of the final reminder for payment of outstanding demand in Form GST DRC 13 dated 5th of March 2026, the petitioner for the first time became aware of the ex parte adjudication order dated 9th of April 2026. Full stop. The learned advocate appearing for the petitioner submits that since the notices the show cause notices were uploaded in the additional tab. The petitioner could not submit the reply to the show cause notice within the time indicated in the show cause notice. So he therefore submits that the order of adjudication is liable to be set aside on the ground of violation of the principles of natural justice. First up, per contra, Mr. Misro, learned assistant additional advocate general, submits that the notices and orders and the notices and the adjudication orders were uploaded in the web portal of the GST authorities and now, in accordance with the provisions of section
169 read with 161.
169 of the WBGST CGST Act, read with rule
161.
Read with rule 161 of the rules framed thereunder. First up, he thus submits that uploading in the normal tab also amounts to compliance of
uploading the additional tabs also amounts to compliance, sufficient compliance.
Submits that uploading of notices and orders in the additional tab amounts to sufficient compliance of the requirements under the statute. First up paragraph, it is heard the learned advocates for the parties and peruse the materials placed. First up paragraph, record reveals that the a show cause notice dated. What is the date of the show cause notice?
Yes,
Malad 8 December 2023.
Dated 8th of December 2023 was issued in respect of alleged, in respect of short payment of tax. No, Kivalam show cause notice was issued, dated such and such was issued as it was found after examination of the returns filed by the petitioner for the period 2018-2019 that excess claim of ITC has been made by the petitioner. First up, a reminder letter dated 2nd of March 2024 was also issued. First up, it is not in dispute that the show cause notice and the reminder letters were uploaded in the additional tab and not in the normal tab. First up, it is now judicial paragraph. It is now judicially settled that uploading of notices and orders in the additional tab cannot constitute sufficient communication of the requirements, sufficient communication in terms of the provisions of section 73 of the WBGST/CGST Act 2017. First up, that apart, after going through the summary of show cause notice and the reminder letter, this court finds that though a date for submission of reply to the show cause notice has been fixed, but no date for personal hearing and the time and venue of personal hearing has been fixed. First up, देखिए GST Act 73(9). Is it 73(9) which says that? Yeah.
My lord, 75(4), personal hearing compulsory is my lord 75(4).
Section 75 within bracket 4 of the WB GST Act 2017 states that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. So, stop. It is not in dispute that no, it is not in dispute. No. Issuance of the grounds contained in the show cause notice. From the grounds contained in the show cause notice, it is evident that an adverse decision was contemplated against the petitioner. Full stop. Thus, it was thus the authorities were under a statutory obligation to afford an opportunity of hearing to the petitioner. Full stop. As observed herein before, that no date, time, and venue of the personal hearing was fixed in the show cause notice as well as in the reminder letter. Full stop. Thus, this court is of the considered view that the provisions of section 73 within bracket 9 read with section 75 within bracket 4 of the WBGST Act 2017 has not been complied with by the authorities. First of all, for such reason, this court is inclined to interfere with the order impugned. First up, since reply to the show cause notice has not been submitted, and it is the specific case of the petitioner that they were not aware of the issuance of the show cause notice at the relevant point of time, this court is inclined to grant an opportunity to the petitioner to submit a reply to the show cause notice. First up, paragraph, for all the reasons as aforesaid, the ex parte order of adjudication dated 9th of April 2024 is set aside. First up, the petitioner is granted liberty to submit a reply to the show cause notice within 14 working days from the receipt of a server copy of this order. First up, the which respondent?
Two.
The Assistant Commissioner of State Tax Siliguri charge, being the second respondent, is directed to fix a date of hearing and to decide the issues raised in the show cause notice after affording an opportunity of hearing to the petitioner as expeditiously as possible. First up.
Section 169 said, and I give my solution. Instead of 142.
142 rules to have a 142 section to 169 jeta Mr. Misro Jason. Yes, next.
My lord, may I just point out item 90 is also on the same issue, my lord, that additional tab issue.
Item
90.
Yes, 90.
Yes, my lord. It is not
Yes,
reaching
let me
every
call
day.
serial. Yes, next. Yes. Call the next matter. 77. Yes, who is appearing? Yes, who is appearing? 77, who is appearing? Din, file din. Data. Career advancement. None appears for the petitioner at the time of call. No accommodation has been sought for either. State is represented by its learned advocate. Since the petitioner is not represented, the writ petition stands dismissed for default. Next. SIR disposed of. Next. 79. 79, yes. What is additional increment? Then what is this? Yes, yes. What is this? Yes, who is for the state? Have you got instruction? So this is to CPF to GPF. Yes. He is not entitled. Then file a report. Submit a report. Who shall file the report? Who is the appropriate authority? Let a report in the form of an affidavit be filed by the respondent number 3 and 4 with regard to the issues raised in this writ petition within how much time? 2 weeks? Within 2 weeks from date. Full stop. Exceptions thereto, comma, if any, comma, be filed within a week thereafter. Full stop. Parties will be at liberty to mention this matter for inclusion under the heading hearing after expiry of the period fixed for filing of the report and the exceptions thereto after. Full stop. Yes, next.
My lord, in
Call the
item
next
number
matter.
80, in item number 80,
yes.
my lord,
Yes.
item number 80, I am representing the customs department, my lord. Kindly,
Yes.
my lord, kindly fix it tomorrow, my lord. I will appear physically and make my submission. My lord. 1 day accommodation.
Release the vehicle. 110A. So you consider the pair under 110A.
Already considered 15% security deposit has been ordered.
Oh, you are challenging that?
But
Then
yes, they
an
are
accommodation
challenging the
has
order.
been sought for. An accommodation has been sought for by Mr. Bonik, learned advocate appearing for the customs authority. This matter in the next week under the same heading. Yes, next.
Grateful, man. Grateful.
Yes, call the next matter. Monday. Where is Mr. Rai? Why he is in Kolkata? He'll come down on the prayer of the learned advocate for the petition. List this matter in the next week. Yes, next. 82, yes. Yes. 82 though.
But after a lot of ordeal for 4 days, the matter has reached finally today.
Yes, yes.
Here is the affidavit of service, which may be kindly.
Yes, who is
taken on
appearing? You are
record.
appearing. 1 and 2. Who is the answering respondent? 2. Yes, yes. What is this matter?
My lord, affidavit of service may be kindly taken on record, my lord.
Yes, yes. Taken on record. Yes, next.
My lord,
What is
the
the submission?
submission is, my lord, I am a school which has been granted accreditation by the NIOS. Distinct accreditation has been granted. One is for the persons with persons with disability, that is specially able children, and one for the normal children. I will draw your lordship's attention to page number 26 and 27, the accreditation letters. 26.
No, did you reply to the show cause notice?
My lord,
Page 50 and 54 is the relevant for the repetition. Page 50 is the scopus and page 54 is the order.
Yes, what?
Page 55 is the reply. Now page 50 scopus you not see.
Yes.
Second.
my lord,
Special accredited institution for education of the Divyangs and its certification from the DFID Council of India and or a certificate of the person with disability PWD Act 1995 from the concerned state government was an essential key requisite.
Yes.
Second, whereas that the normal center school
Does not possess.
Yes, sir.
my lord, kindly allow me.
Let him.
My lord, kindly allow me for the submission, my lord.
Yes.
My lord, there is two distinct accreditation. One is for the specially able children and one is for the normal children. Now, for the normal children, this RCI certification or PWD certification is not even required. So, by one sweeping order, they have disaccredited both the accreditation, which is absolutely illegal. When the accreditation for the normal children does not require the certification, it's not understood how the order has been issued. The deaccreditation has been issued.
Please show me the provisional accreditation certificate.
My lord, that is what? Page number 26 and 27. 26 is for the specially able children and 27 is for the normal children. They are two distinct.
Give me a minute.
Yes, my lord.
Yes. Yes.
So, my lord, the concern is that I do agree that at that point of time, that provision RCI certification or PWD certification was not in my possession for the first one. However, there is no requirement for the second one. So now it was in the process of acquiring, which I have already acquired. Now my question is, the whole ordeal began with something else, my lord. I was granted accreditation from the year 2021 and subsequently from 2021-22 academic year, my lord. Now in 23, officials visited. There are many other study centers which are accredited in this region. Now, what I did, I had complied with the NIOS guidelines that displaying of my accreditation in a signboard in my school. That is the guideline says. Now in that, this board, I had disclosed the fees, I had disclosed the methods, everything for the awareness of the children. Now, this caused the whole issue. Suddenly, in 2023, couple of officials visited my school during the exam. I had nothing to hide, so I welcomed them with open arms, carried out all the inspection, whatever they wanted to. And when they found no irregularity, thereafter the full of harassment of asking for document began. Now, immediately after that visit, they started sending the emails seeking the documents which I had already submitted while submitting the application for accreditation. Now, this I will draw your lordship's attention to page number 32. What are the documents they asked for? Serial number 1, 2, 3, 4 in the mail, my lord, where there is no mentioning of PWD certificate. First thing.
Yes.
So, my lord, when I replied them, subsequently I replied them that these are the documents which are already submitted while seeking the accreditation. Now, my lord, I will draw your lordship's attention to page number 34, where they themselves have accepted, rather admitted, that Regional Center Gangtok has written to the NIOS headquarters that file at the bottom of the page, my lord. The file for accreditation of AI number 450178/460531 was processed by RC Kolkata. Hence, SBC minutes will be available with the RC Kolkata. That means they have accepted these documents are already with them. Now what happened, my lord? They shifted the goalpost. How they shifted this goalpost? When I replied that these documents are already in their possession, now they shifted the goalpost by sending a mail at page number 35.
Yes.
What did they ask for? They asked for the RCI certification or the PWD Act certification. Now this time they have not asked for those documents.
Yes.
So, my lord, they did not even realize that for the second AI number, that is 460531, this certificate is not even required. By barrage of emails, they started, troubling me, seeking this RCI certification and PWD certification. Despite, in the meanwhile, my son had suffered a very...
He was run over by a bus.
He was run over by a bus and almost suffered a very bad injury in his leg. I was occupied in his medical treatment. I have submitted all the medical documents, my lord. They did not even consider that. They gave ultimatum of 2 days in that kind of condition that either you submit this PWD certificate or we are going to deaccredit you.
Now
So,
you have that certificate.
yes, my
now.
lord. I have already,
That
I already
certificate is
have
now.
it, my lord.
Can you not reconsider that?
My lord, first thing is that second one,
Page 26.
Yes.
Under application granted by NIOS, documentation is seasonal of application by the if the circumstances and the responsibility coordinator to inform the same NIOS. But see, in the cost title, I'm applying NIOS school. Then Gangtok and others respondents are also there. They referring some mail. Mail between the Gangtok and NIOS.
No, now he has the certificate. The cancellation was on the ground that he did not have the certificate, could not produce the certificate. He is now having the certificate. Can you take instructions on that? Where is that certificate?
my lord, PWD certification.
One, for disability certificate is required, which he does not possess.
He is possessing now.
Then reconsider.
Please consider
My lord,
this.
I will submit for that one.
Where is that certificate?
Now your lordship case.
Have you annexed that certificate?
It's not annexed, my lord. It is.
Did
It
you
has
file a
been.
supplementary affidavit?
I'll do that. But first thing is that is for the first one, my lord. But for the second one, this certificate is not even required,
Considered as a whole.
my lord. My lord.
The fact disputed other record or not, then I will find the affidavit.
Let him first, if he has the certificate, how soon can you file the supplementary?
My lord, grant me a week time or 4 days time, my lord.
On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit annexing the certificate issued by the
West Bengal government, my lord.
Certificate issued by the competent authority. Full stop. List this matter. Then when you want 1 week, then just to go before the next circuit. List this matter before the next available circuit bench. Yes.
Earlier mentioned, I got number 19, Jalpaiguri Municipality Council is here. 1 minute's matter.
4:15 I have said, it's now 4:05 only. Yes, next. All the next matter.
Item number 83.
Yes, 83. Yes, who is for the petitioner?
Deeply obliged, my lord.
Yes.
Lordship, the petitioner before your lordship is a 90-year-old man, lordship. He's
One day accommodation is a single separately started.
Yes, what is this matter?
Matter is, lordship, the petitioner's house is built in 1988.
And it is a pension dilen, ki matter dile.
The
Who filed the dilen abar?
Siliguri Municipal Corporation has passed an order to demolish the house.
Mr. Dhar is not demolishing what is unauthorized, is demolishing what is authorized. What are you doing?
My lord, may I be permitted to appear for the
At times you are not issuing any notice, at times you are.
This is the second round of
High Court had passed the order for consideration of representation of the private respondent. Now
he has found that you have made an illegal construction. What can be done?
It is not an illegal construction. Since 1988,
My
the
lord, they
construction
have
is there.
encroached upon the road, my lord. They have encroached upon the
decided
public
that
road
it
and
is
made their own.
as per the
My lord, can it be
rule
fixed
of
tomorrow, my lord? I'll
2007.
be physically present, my lord. Due to my personal difficulty, I could not be
All
present,
right.
my lord. Kindly.
You are for the private respondent.
Private respondent, my lord.
Lordship, the
My lord,
Private
there's a
respondent. Just on the prayer of the
Affidavit of service.
every service filed in court today is taken on
83.
record. On the prayer of the learned advocate for the private respondent, this is matter tomorrow. Yes, next.
Lordship, kindly affidavit of service be kept on record.
Every service taken on record. Yes, call the next matter.
Lordship, item 84, Lordship, kindly place the matter any day or next week. Service is not completed yet. And the senior counsel is appearing in this matter.
What do you want?
Lordship, only place the matter on any day to next week.
What is the order under challenge?
Lordship, I do not have much instructions in this matter. Your Lordship, senior counsel is appearing. That is why I am praying for the rest of the matter.
Yes, who is appealing for the state? Yes, you are challenging a notice under section 10(1). 10(1) notice, how can you challenge this? Madam, 10(1) is the only to remove encroachment. If not removed, under 10(2), it will be referred to 10(3). Then the adjudication will be made. Thereafter, it's an appellable order. Not next week, tomorrow. Why? You come ready. Please go through this matter. Yes, not today, next.
Number 85.
85, yes. No adjournment, madam. Please move this matter. On the prayer of the learned advocate for the petitioner, list this matter in the next week. Yes, next. 86. Same. Next. Yes, 87. Yes, what do you want? Yes, yes, what is this? Implementation of the ad interim order of injunction. Maybe. Where is the ad interim order of injunction? No, where is the order, Mr. Dhar?
The defendants and the last social orders that are there for order of defendants and the main.
Is the ad interim order? What happened after that?
Not followed by the either by the time respondent.
Mr. Dhar, you are the plaintiff. Have you complied with all the rule 3A, 3B? Have they appeared? Yes, after they have appeared, the injunction order has been extended. Yes. Before the civil court, yes, what has been done? Yes.
The ordered portion, that the petition under section 151 dated for petition is allowed as an instance of the officer in charge of crime to police station shall provide necessary
Defendant has not appeared, Mr. Dhar. Defendant has not appeared. Yes, has not appeared. I asked you, you said yes, they have appeared. I asked you in their presence, it has been extended. You said yes. Please show me the order of extension of interim order. This is 151. 19th of March. Mr. Dhar, very cleverly this application was filed under 151. Yes, please see, because the ad interim order of injunction was passed on 27th of January 2026. The returnable date was on 20th of March 2026. So prior to the returnable date, you have filed an application under 151 for implementation that was allowed. This order is liable to be set aside, Mr. Dhar. How could you procure this type of order under 151? And you are paying that it has not been complied with. How could it be done? How could the learned trial just say the defendant has knowledge and there is violation? 20th is the returnable date, and very cleverly on the one day prior to that you have filed 151. This shows you are not in possession. No. Then you would not have filed this application one day prior to the returnable date. Have you served upon the private respondent when they have received? Dakanto, evidence service, sir. Can an ad interim order of injunction be implemented with police help? An interim order of injunction can be implemented with police help. What happened? What happened on 20th of March before the civil court? Please give me the order of the page 67. No, this is of 19th of March. Please show me the order of 20th of March. Yes, service was not complete. because you are directed to file fresh requisite both ways. Then how could the order on 19th be passed saying that they have knowledge? Mr. Dhar, better please withdraw this. Otherwise, if I proceed with this, we'll be having difficulty. Because I am bound by my own order. An interim order cannot be implemented with police help. Yes, yes. Not complied with. Service both ways till date. Service has not been complied with at 151. You are out of possession and you want to enter through police. Yes, has to be. Please go through the judgment of come tomorrow. On the prayer of the learned advocate for the petitioner, list this matter on Monday. Every service filed in court today is taken on record. Yes, call the next matter. Yes.
I am for the petitioner. Can you audible, my lord?
Yes, what is this?
This is the matter relating to enemy property. My junior is there. He perhaps he submitted the video of service. So that what happened in the year 1965, the property belongs to the petitioner predecessor, but registered as enemy property. Enemy property Act 1916. Thereafter, year 2019.
Yes, who is appearing for custodian of enemy property? Who is appearing for custodian of enemy property? Union of India, who is appearing? Yes, Mr. Singhania. Copy, sir.
Yes, Lord.
Please give a copy. Yes, when can you come back? When can you come back?
Next week, in the meantime,
Monday.
Dear Lord, kindly hear me. There is some urgency. If you Lord kindly take the page.
Yes.
My Lord, page. I'm coming, my Lord.
Yes.
Just a second. A letter issued by the BLR during pendency of the appeal under section 18. A letter has been sent by the BLR concerned. Did you kindly have a look page 89?
Page
89.
Page 89.
Yes. But date of hearing is scheduled. This is issued by under section 57. Kindly have a look to body. Date of hearing is scheduled on 18/6/2026 at 12 p.m. The office of the BLRO to be connection with the letter from this setting. Now, as per my section 18, appeal is pending. Several hearing was done by both the parties.
No, 18th June was the hearing. What? 18th June was the hearing. Today we are on 23rd.
No,
so I'm keeping it on next week.
No, my lord. But there
nothing will happen.
Continuing the proceedings, kindly give the undertaking taken by Malayan State of behalf of the Malayan Union of India that no further process will be done.
No. Hearing, please appear. Nothing. Ashun.
In the meantime, otherwise, my entire matter become infectious.
What will happen? Nothing will happen. Section 50, Section 57 notice is only for to attend the hearing. Section 50 is the correction of record of rights.
Yes,
sir. Please hear me.
My lord. Thereafter, my lord, they
Sir,
are
section
continuing the
fif-
proceeding, and every day they are going to the plot, including the petitioner resident, to take our position. My lord, appeal is pending, and under section 18B, 18C, subject to section 18C, that no proceedings. There's no court has.
Where is the order? Where is the order which is under challenge?
But that is my lord, the vesting order. That is not serving. So why, my lord, I have preferred an appeal as per provision of law under section 18 before the custodian of uniformity.
Sir,
And my lord,
hearing, sir, please hear me. Please hear me. The hearing was fixed on 18th of June. I'm keeping it on next week. Ashun, let a copy of the writ petition be served upon Mr. Singhania, a learned advocate. Yes. Yes. Let a copy of this writ petition be served upon Mr. Singhania, learned advocate who usually represents the respondent number, who usually represents the Deputy Secretary, Custodian of Any Property of India, being the second respondent. So, sir, let a copy of this writ petition be also served upon Mr. Misro, learned Assistant Additional Advocate General for the District Magistrate and the Block Land and Land Reforms Officer. List this matter in the next week. Yes, next.
109.
Yes. Yes.
Very good.
Who's appearing?
My lord, I'm appearing on
Yes.
behalf of
Very
the
good.
petitioner, my lord.
Yes.
My lord, on the other occasion, my lord, I argued on the issue that it is the central who has jurisdiction over me and not the state. And my lord, then the CGST said
Yes.
that this is not maintainable because he said that it is the.
No, CGST. Have you informed the CGST?
Yes,
When?
my lord. Yes, he has been informed. And
Not
and he
today you have
appeared, I
mentioned
just saw
for
it.
fixing it.
Time of mentioning.
My lord, he.
Personally inform Mr. Boni that the matter
My
will
lord.
be called on and matter. He or junior will be there.
No, it's not there.
The answer is the state one. The state is the answering respondent because I am challenging that.
State, Mr. Misro, you are appearing. Yes.
My lord,
Yes,
so
yes.
Mr. Bonik said, my lord, Mr. Bonik's submission was that this court has no jurisdiction, it should go to the principal bench. My lord, my submission is that the state has issued from the, if your lordship sees the order, it is from the Siliguri unit. My lord, kindly come to page 75. So it is from the Matigora, it is the page 75. My lord, Office of the Special Commissioner GST, Bureau of
Yes, Mr.
Investigation.
Misro, what do you say?
Yes.
My lords, I have gone through the copy of, I didn't have the opportunity to listen to my learned senior. I have gone through the copy of the writ petition. There are a couple of points that has been taken there. One is the lack of jurisdiction of the state authorities. The second issue that has been raised by them is that the intelligence ITC unit, which was declared against the provision of such the Service Tax Act is not the proper authority. VAT Act is not the proper authority under the GST Act, and therefore they shouldn't have taken the action. And then there are other points. Violation of natural justice always is there. Other than that, the additional tab and notices is also there. Now, my contention is that if they are banking upon additional notices and tab, then everything boils down to additional notices or tab. If they say that they want to have it on the other points, on the points of jurisdiction, then we can argue on that and we can finish it off. But then they will not be taking the additional tab.
No,
Yes,
my lord.
yes,
My
Mr.
submission
Mukherjee, what do you
is,
say?
my challenge is to the jurisdiction, but my delay in filing
Jurisdiction,
the
then we
appeal
will come to
was.
jurisdiction.
Yes.
If I can have my lordship for a moment, on my lords, there how the VAT Act, previously there was a VAT Act and then the GST Act came. Now, my lords will recall, there is an Article 246 of the Constitution, we deal with it on a daily basis. Article 246 of the Constitution, my lord, says that there is 3 different lists under the Schedule 7. One is a central list, one is a state list, and one is a concurrent list. Now, in Article 246 of the Constitution, my lords, what used to happen was it has a very watertight compartment built. What is stated there, my lords, is that everything that belongs to the list 1 has to be, there is exclusive jurisdiction of the union government or the parliament thereon.
Yes.
Something that is there in the list 2, there is exclusive jurisdiction of the state legislature thereon. And then there are concurrent lists. We are all aware what happens in case of a concurrent list. Previously, what used to happen was that all these indirect taxation used to fall under entry 84 of list 1. Because list 1 was for the union and union has to collect the indirect taxation. Therefore, by virtue of entry 84, it used to be done. There was only one exception to that. That was 92C. By virtue of it, the service tax and everything came. Then, my lord, there is an entry 54. The state has an authority to collect indirect taxes based upon 54. Some of the examples, my lords, of taxes that were imposed by the union, my lords, it started with the Central Excise Act. Then, my lords, there was another one, additional duties on customs and everything. All those, they found their flavor from entry 84 that was there. Then what happened, my lord? And in case of 54, my lord, the state also had the authority. The state came with the State VAT Act. The state came with Entertainment Acts, Lotteries Act, and then the state came up with other act. Even in case of central sales tax also, the state was the collecting authority. It was given to the center. That is how the scheme of the act was. Then, my lords, in the middle of a financial year, on June 17, came the GST. Now, generally, my lords, the financial year is from April to March. But here in the middle of a financial year, by way of a 101st Amendment Act, my lords, the GST was brought into place. Now, when the GST was brought into place, my lords, there were certain central acts and certain states acts that got subsumed in the GST. They no longer existed. And there were amendments that was done to the entries also. So this entry 84 under the first list of the 7th schedule, that also got amended because central lost most of its power except for lots tobacco and petroleum. And in case of state also 54 was amended to the extent that state also lost all its power of taxation, indirect taxation, except for petroleum and liquor substances, yes. So when the GST came into place, the GST Act was implemented. The object and the reason behind the GST Act was that there would be concurrent power of the center and of the state. And there were 3 different kinds of taxes that was implemented. One was the central tax, one was the state tax, and one was the ISGS. Now today, if I have to point out 5 basic differences between the VAT Act and the GST Act, first of them, would be that VAT was based on the origin of the good, whereas in GST it is a destination-based tax. That is the first difference. As a student law, that is the first difference that we will be able to point out. The second distinction, would be that in case of a VAT, 100% of collections happens with the state and it is kept with the state. But in case of GST, that is not what the case is. What happens in case of GST is that, for example, if this is a pen and if this pen is subjected to 18% of the GST, then 9% of it will go to the center and 9% of it will go to the state. And because it is a destination-based taxation, therefore, also what will happen is that if this pen has to be sold from West Bengal to Assam, then because Assam is also central and West Bengal is also central, then in that case, it will be IGST 18%, but the receiving state would be center and Assam. West Bengal will not be the receiving state. So these are all basic fundamental difference that is there between the VAT Act and between the GST Act that is there. The question, my lords, that has been brought before today, my lord, before my lordship, is based upon 2 distinct points. One, my lords, is that has been raised with regard to an authority called the Intelligence ITC Authority. They say that such authority has been declared as an ultra-virus authority or the authority not constituted under the Act as per the old VAT Act. Now, my submission to that, my lords, is that that circular was issued in 2014. In 2017, the entire law changed. The VAT itself was not into place. It got subsumed within the GST. And therefore, and the circular by virtue of which they has been transferred from the VAT authorities to the GST authorities is not under challenge. State GST authorities is not under challenge. They are banking upon an order that has been passed by the state tribunal, state taxation tribunal. So that authority itself has been superseded by statute. Now, unless and until a fresh challenge is brought as to whether that authority acted, originated in accordance with the Act or not, or is acting in accordance with the Act or not, that challenge is a little bit downplayed. The second thing that she has raised is very important thing. She says that if a person is registered under the central GST, then that person will not be subjected to the jurisdiction of the state GST. That in my humble submission, Lords, is a little bit fanciful. I will explain why. When a person applies for a GST registration as an RTP, Lords, he simply puts his application in the portal and the GST registration automatically comes. Now, a person at that point of time does not have a choice to choose between the SGST or the CGST authority. It is done randomly. So whoever approves it first, if I am a CGST officer, if I approve it first, then it will come under the CGST, the registration. If I am a SGST officer, if I approve it first, it will come under the SGST. Why such kind of a scheme is there, or why it is done that way? That needs to be understood, my lord. First is, if I can have my lordship for a moment on, because section 6 has been relied upon them by very heavily. If I can have my lordship for a moment.
How much time it will take?
How much time?
My
15
lord,
more minutes.
my lord,
Tomorrow.
my
Yes.
lord,
Yes.
tomorrow then
Yes.
I am appearing on behalf of the CGST department, my lord.
No, we
Yes.
can finish it up today. I will not take more than 15 minutes.
They will be replying to that.
Oh, they will
Yes,
not
my
give
lord.
any reply. I am sure about it.
No.
What can you hear me it out?
No, Mr. Bonik.
Another
will be-
15 minutes.
Mr. Bonik.
Oh,
will
Mr.
be-
Bonik will say whatever I will say.
Yeah, Mr.
Yes.
Bonik will be
He-
there.
My lord, it cannot be
Mukherjee
that
will also
Mr.
be
Bonik
there.
has to
interested in
say
the
what is the law. My
Ma-
lord, it cannot be
Ma-
that Mr.
my
Bonik
lord,
will say whatever he says.
Section 6. My lord,
All right,
section 6. I am agree.
Mr. Misro Lanet, Assistant Additional Advocate General, commences his argument but could not conclude due to paucity of time. List this matter tomorrow under the same heading.
2 p.m. fixed.
My lord, only thing, my lord, let it be upgraded so that, my lord, it does not go at
No, no,
the bottom.
10:30
Many matters
I am
have
in the
been,
division. 2 p.m.
It will be fairly, no, not 2 p.m. It will be fairly at the top. It will be reaching tomorrow because
My lord,
up to
my lord, it will be
88
at 2
are
p.m.
finished.
My
And
lord, it will
yours
be at
is
2.
109. Previous matters have also been fixed. And after your matter also from 115 to 131 also has been completed. Yes, 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 Mr. Singhania.
Kindly 92, today's history, that's it.
Where is Jalpaiguri? Yes, 92 ta din to.
My lord, 109, it will be at 2 p.m. tomorrow, my lord.
Tomorrow. No, I'm
Tomorrow
not fixing any time. It will be serially taken up.
Grateful.
Yes,
But there is very unusual.
yes,
Petitioner is a single mother, your lord.
yes.
He married one person, Padmu Mondal, one baby child was born. Now, in accordance with law, birth certificate was issued wherein the mother name is Ankita Mandal, father's name is Padmu Mondal, and daughter's name is Akriti Mandal. Now, subsequently, she get the divorce, your lord. And at present, since long, child is the mother. Now, the child is class 9. Registration is required for the board examination. Now she used the surname, your lord, she is Korea. Earlier, sir. So my humble request, before the one birth certificate be issued, mother's name Ankita Korea, daughter's name Akriti Korea, and father name is Bharta Mondo, the biological father.
How can you say divorce may have been between the father and the mother? After all, she also is this daughter of the father. Have you impleaded the father? Please implead him. You have not impleaded him.
The father's name is always the father name.
No.
I am not-
The surname also. How can you change that surname without the father's presence? No.
This problem.
This is not done.
Otherwise, you are saying in the very long mother resides with the Korea. Here this big problem is that
No problem will be there. What will be the problem? There will be no problem. It's only ego, Mr. Singhania. It's only ego. Nothing more than that.
culture and customs is
You have to impede the father.
mother already changed his name. In Korea.
Mother's name, there is no dispute, mother's name. But there may be a divorce between the husband and the wife. But there cannot be a divorce between the father and the daughter. I'm telling you, Mr.
But use of the surname your lords.
If the father wants, yes, my surname will be with the daughter. How can you oppose to that? Why are you objecting to that?
I understand.
Then that's the problem. Please impede the father.
last first week of the August is the last.
You
time
should have approached the authorities.
I
You should have
already
implemented.
approached.
No, you should have made the father as a party.
Others, address and others, totally unknown.
No, it cannot be. Then it's difficult, Mr. Singhania.
But let's see, use of the surname is my choice, Lordship, sir.
Why? Why your choice?
A single mother.
Maybe.
But she's a single mother. That
Maybe.
father's, not say, since 10 to 12 years, father did not care his child, your Lordship.
That's neither here nor there. That's neither here nor there. Mr. Singhania, you are fighting with that. You don't know what will happen after she attains 18 years of age. After she attains 18 years of age, you don't know what will happen. What is her age now? 15, 14 or 15? So 2 or 3 years, you don't know what will happen. Let it remain, nothing will happen. If the father's surname is there, it's only ego, Mr. Singhania.
The customs are clear. Korea is the, I'm disclosure, Lordship. Here is the Marwari community, your Lordship. And it's a reputed family. Now, at the age of 18, she married one Partha Mandal. Now, subsequently, did not achieve the Partha Mandal as because your Lordship said did not care.
That is why I told
Say
you it's a
return
ego.
back- Say return back his paternal family. Now she brought up his family. Now it's the registration. Child's daughters, your Lordship, in future. Marriage and others, everything.
So
your
please,
Lordship.
please implicate the father. Otherwise, it's difficult.
This address is the address. How will serve the copy?
That's your carriage of proceeding lies with you. Carriage of proceeding lies with you.
And as a single mother, there was a notification principle will apply and attach the notifications also, your Lordship. That is.
Where is that notification? Where is that notification?
32 years. Here I annex the marriage certificate, birth certificate, divorce degree, ABDD, representation, and here the I card of the Akriti Korea school. In the school also they admitted as Akriti Korea. At page T632, wherein your Lordship is the category stated a single mother can also entitle to birth certificate only his name. And the same principle apply in this case also, your Lordship. And date of divorce, your Lordship, page 13 in 2016. And prior to that,
You have the copy of this judgment. Please bring this judgment of the Honorable Supreme Court.
Lordship.
Please bring the judgment and please implicate the father. Please implicate the father, please.
It's very difficult, your Lordship.
Why?
I have no objection, if the court permits, but service is very difficult.
Why?
Because this person, your Lordship, where she resides. the
Yes, what is
petitioner
your
was-
instruction?
My lord, municipality has no objection. It's between them, both father and mother, my lord. Whatever order my lord passes will abide by that. There is no objection on that.
Otherwise,
Not in that way. It cannot be allowed in that way. Court cannot pass an order that
then
direct.
your Lordship, then one thing. Allow me to add the father's name, along with the paper publication, we can raise your Lordship.
That you do. Please try to serve thereafter paper.
Lordship, I have.
On the prayer of the learned advocate for the petition, leave is granted to the petitioner to add the father of the minor daughter Akriti Mondol. Akriti Mondol as a party respondent. in the-
Parthu your Lordship. Father's name Parthu Mandal.
Yes, father of the minor, I have said. As a leave is granted to the to the petitioner to add Partho Mondol, that is the father of the minor daughter, namely Akriti Mondol, as a party respondent in this writ petition. So, stop petitioner is directed to serve a copy of this writ petition upon the added respondent and file an affidavit of service on the next date.
Paper publication, pass an order.
Please
And
try
it can
fast.
be Wednesday, your Lordship.
Please try fast, then paper publication. Wednesday, list this matter on Wednesday.
Lordship, affidavit of